please, Your Lordship. Lordship, kindly adjourn item number 48 and 15. My senior ST forecaster is on leave.
Forty-eight.
15.
Okay, and 15 to be listed again on 4th of April 2025.
Obliged, Lordship.
Yeah.
Please, Your Lordship. Just to mention item number 10 of today's list.
Hmm.
We have taken the concern of the planet counterpart of the petitioner side, my lord. So we are, on behalf of finance department, we are required to file an affidavit. And bring for further 2 weeks time, my lord. We have already communicated. They are preparing the, my lord, instructions for you.
Mr. Gorpujari, I will grant accommodation at that time when the matter reaches. I don't grant accommodation at the time of mentioning for
My
filing.
lord, I'm so obliged.
Item number 25, and
Yes.
allowed to withdraw the case.
What is this matter about?
Dispute between the tenant and
I'll do the
we are for the
I'll do
applicant.
25. Just wait, let the others. Yes,
With Your Honor, I beg to mention item number 44. We have filed an affidavit in support of justice service. So that may be possible.
item number 25, no? Mr.
Yes, Islam.
S. Islam, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition. Consequently, the instant petition stands closed on withdrawal.
All right.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 26 for an adjournment. We have taken consent from the other side. We are from the side of respondent.
What is this matter about?
I'm not aware of this, Your Lordship.
Don't mention then. Next,
My citizens. Hello, I have the instruction to not place the item number 28, madam.
20.
8, madam. This is a matrimonial dispute, madam.
There's a stay.
There is a stable that may be
Now,
there.
I think it's 28.
20. They have settled their dispute now, madam, as has been instructed. Yes.
Your name?
NZ does.
Mr. N.J. Das, the learned counsel for the petitioner. Mr. The learned counsel submits that he has instructions to withdraw the instant transfer petition. Accordingly, the transfer petition stands closed on withdrawal. The interim order dated 4/1/2023 stands vacated. The learned court of the principal judge, family court number 3, Kamrud Metro, shall proceed with the adjudication of FC civil case number 958/2022. The registry shall intimate the instant order to both to the learned court below.
I'm deeply aware. Deeply aware.
Lordship, item number 23 has become infructuous.
20,
3.
infructuous, why? Twenty-three, file to the 23.
23.
Your name?
D Devi,
You're not there.
on behalf of D Nath.
No. Yes, Mr. Dinath. Tell me what is this? Why is it infructuous? Why infructuous?
Another FA was filed. Against the judgment and degree, we prefer an appeal. So there was a stay in that, the delay, after the convocation of delay, they preferred a FAO, and ultimately lordship has passed the order and sent both the parties to the suit. So in the title appeal. In the title appeal, some order has been passed. But ultimately, our convocation petition was ultimately that was dismissed. But
Heard Mr. Dinath, the learned counsel appearing on behalf of the petitioner. First, the learned counsel submits that the instant application filed under Article 227 of the Constitution, challenging the ex-parte decree dated 30/6/2007, passed by the Court of the Learned Civil Judge number 3, Kamrup at Guwahati, in title suit number 50 of 2002, had become infructuous. Taking into account the above, the instant petition stands closed on withdrawal. The interim order passed on 4/12/2024, 18 stands vacated. Yes, Mr. Sahad.
the 3 meters are connected.
Motion item 1, 2, 3.
What are these matters?
One have instituted title suit number 148 of 2021 in the court of Learned Civil Judge, Junior Division number 1, Tezpur. Now, having received the summons, he appeared and contested the suit.
What are you challenging?
Now, Lordship, what happened when after framing issues, the learned trial judge have fixed the matter for filing affidavit of evidence from the plaintiff side. He is respondent 1. At that time, one stranger, he is not a party, filed 3 petitions before the learned trial court. One under section 151 CPC, stating that he has been newly appointed as secretary of the respondent number 1. He is a society. And therefore, he may be allowed to represent the suit. That is one. Secondly, he filed another petition wherein he stated that that petition is filed under Order 12 Rule 8. Order 12 Rule 8 for passing an order that that is defendant number 1 may be directed to produce all the documents in original for their exhibition, for marking as exhibit during the evidence. That is one. Now, we also oppose them. Then third one is that he wanted to produce his appointment letter as secretary of the respondent 1. And another photocopy of a notarized power of attorney he has given to one Devan Bhangra. And all the petitions were opposed. As because in their plain, it is Annexure 1, page 11, 12, 13, 14, 29, up to 36. Plaintiff, the Agostino Evangelical Lutheran Church, defendant number 1, the petitioner hearing, and 2 other three other defendants. Here in interesting part is that the here in respondent number 2. Respondent number 2 was earlier secretary of the respondent number 1. Now, during his tenure as secretary, he had executed a registered sale deed in my favor sometime in the year 2012.
Yes, tell me.
Yes.
Yes.
2012. And now they are saying that my registered sale deed may be cancelled and my mutation may be cancelled. Actually, it is a land for college. A college was established over the land and college was going on. But due to their disturbance,
Mr. Sahad, let us come to the point. The person concerned says that the suit which was originally filed through Mrs. Surya Kujut should now be continued to that person concerned.
Yeah.
As now he is the secretary.
actually during tendency of this, actually their society has
Mr. Sahad, let us
cancelled.
not digress unnecessarily. He wants that he now is the secretary, so he should be permitted to represent the petition, the plaintiff, who is the. Now, the trial court must have allowed that petition under 151. In fact, this is a petition, more particularly a petition under the Order 22 Rule 10.
151.
151, they may have used it, but it is a petition strictly within the purview of Order 22 Rule 10. What is wrong with that order?
Logic, whether there is a provision, order 1 is itself very much.
Not Order 1.
Yeah.
Order 1 does
Or-
not come in.
or-
Mr. Sahad, Order 1 does not come in. It will come under Order 22 Rule 10.
Right.
Because there is a change, there is a Supreme Court judgment also on this point in 1972. That was a case as regards the Mahant of a temple where the Mahant changed, so they wanted to bring him out there. So because the earlier Mahant died, the trial court and the High Court passed orders that this was delayed, it could not have been done under Order 22 Rule 3. The Supreme Court said, no, this is not an Order 22 Rule 3, it is an Order 22 Rule 10, by which there is a change in the position, by which it is a different person who has now going to represent the plaintiff. So what is wrong?
Actually, what?
Now, my next question is Order 12 Rule 8.
Yeah.
Order 12 Rule 8 is a petition which is the form given in terms of Section 66 of the Evidence Act. So he has asked you to produce. He has asked you to produce in that particular appendix form. Now, if you don't produce it, he gets the right to produce, come under Order 65. So what is wrong?
Lord Chief, actually,
And what is the third application?
third application for protection of their appointment letter and one notarized copy of power of attorney he has given to some third party.
So what is the learned trial court hold it?
About
So the production, if they make it, that will you put it under objection.
Lord Chief, after going through the claim, if in their claim,
No, Mr. Sahad, kindly appreciate, order, when they want to produce a particular document, that will be a leave being sought for under Order 7 Rule 14.3. This is a leave being sought for under Order 7 Rule 14.3, being the plaintiff. So this leave was being granted. When they produce it, you put it under objection.
while product, there is a provision for production of documents, that is form number 2 and 12, appendix C. They are not doing.
See, this particular appointment letter was not there at the time when the suit was filed. The suit was filed subsequently.
There is no such assignment. That is my question.
No, that is the petition which, on which he has filed a 151, saying that now he wants to represent. Because tomorrow you are going to put a question that what is his authority?
So Lordship, I may be allowed to read out. Order 7, Rule 14. Documents relied on in plain. 14.
Order 7 Rule 14(3), come to that.
Lordship. Documents relied on in plain. 14. Production of document on which the plaintiff sues or relies. Where a plaintiff sues upon a document or relies upon a document in his possession or power in support of his claim, he shall enter such document in a list and shall produce it in court when the plaintiff is presented. That is first rule. Lordship.
Come to 3.
And
Mr. Sahad, come
I
to
will be going.
2. I don't want. 2 is only for the
Yes,
purpose
Lordship.
that if he doesn't have the document, he has to say where the document is.
Yeah.
Now kindly to come to order 7 Rule 14(3).
3. A document which ought to be produced in court by the plaintiff when the plaintiff is presented or to be entered in the list to be added or annexed to the plaintiff, but is not produced or entered. Accordingly, he shall not, without the leave of the court, be receiving evidence on behalf at the hearing of the suit. But we have not even mentioned, there is no such mention in their plaintiff. That is my question.
Obviously, that is why this has happened during this time. During the pendency, this person has come in. So this is a thing which has to be brought on record by bringing on record date, because tomorrow you are going to put a question at the time of cross-examination of him. So what is your authority?
Lord.
How will he adduce evidence? He has to adduce evidence out there on the basis of that document. That look here, I have been authorized. Now I am the General Secretary. So this is the document.
Besides that, Lordship,
So what do you want? Dismissal or withdrawal?
it should be hard.
No, hearing is over. Now tell me which one you will. There's no fault of the court. Which one? Either of it.
No.
Dismissal. Heard Mr. A. Sahad, the learned counsel, appearing on behalf of the petitioner. Pusto. The 3 applications that this court, by the present order, dispose of the 3 applications. That is CRP number 69 oblique CRP IO number 69 oblique 2025. CRP number CRP IO number 74 oblique 2025 and CRP IO number 82 oblique 2025. Taking into account that all these 3 applications have been filed in connection with a suit being title suit number 148 oblique 2021. First. It is seen from the materials on report that the defendant number 1 herein, the respondent number 1 herein, as plaintiff had instituted a suit being title suit number 148 oblique 2021, seeking declaration of its right, title, and interest over the Schedule A land, semicolon, for recovery of khas possession of the Schedule A land by evicting the defendant number 1 and his men, agents, etc., along with their materials, semicolon, for cancellation of the sale deed being deed number 1814/2012 of Tezpur sub-registry, declaring it to be null and void and inoperative, semicolon, for cancellation of the mutation orders dated 19/2/2013 passed by the circle officer, semicolon, mutation entries in the name of Emmanuel Junior College passed on the basis of the sale deed as mentioned in Schedule B, declaring it to be null and void and inoperative, semicolon, and for consequential relief for permanent injunction. It is very pertinent to mention that the suit was filed by the plaintiff through its general secretary, one Mrs. Sujaya Kujur, Sujaya Kujur. Full stop. In the said suit, a written statement was the defendant number one, who is the petitioner herein, had filed their written statement. Full stop. While the suit was proceeding, the three applications were filed. One was an application filed under section 151 of the Code of Civil Procedure to bring to the notice of the learned trial court that the said applicant, Sri Ishwar Dutt Kandulna, was appointed as the plaintiff's general secretary, and he had taken the charge and had appeared before, had taken the charge. Full stop. One application was filed by the respondent number 5 herein, that he has been appointed as the general secretary of the plaintiff, and he has taken over the charge of the plaintiff society. Society, no? Society. Full stop. The said application was registered and numbered as means the case number 304 of 2023. The respondent, the defendant number one herein, who is the defendant number one, who is the petitioner herein, have filed written objection against the said application. The learned trial court, by the order dated 5/9/2024, allowed the said application. And accordingly, allowed the said application. And it is under such circumstances, CRP IO 69/2025 was filed. Next. The respondent number 5 further filed another application the respondent number 5, on behalf of the plaintiff, filed another application under Order 7 Rule 14(3), read with Section 151 of the Code of Civil Procedure, seeking leave of the court to produce the copy of the appointment letter issued in his favor, in favor of the respondent number 5, and also a notarized general power of attorney executed by the General Secretary in favor of one Deban Chandra Bengra on 30/8/2023. Full stop. The said application was registered and numbered as means the case number 303/2023. The respondent number, the petitioner herein, who was the defendant, had filed written objection. And the learned trial court, by the order dated 5/9/2024, allowed the said application, thereby granting leave to the plaintiff to produce the documents so mentioned in the said petition. It is under such circumstances, CRP IO 74/2025 was filed. The third petition so filed by the plaintiff through the respondent number 5 was an application filed for passing appropriate order against the defendant for production of documents as mentioned in the said application. Full stop. This application, though have been filed in terms with Order 12, Rule 8, read with Section 151. But essentially, it was an application under Order 11, Rule 14 of the Code. The learned trial court, the defendant number one, that is the petitioner herein, had filed written objection. And the learned trial court, by the order dated 5/9/2024, in Ms. Z case number 302/2023, allowed the said application, thereby directing to produce the documents in original at the proper stage of the trial in order to enable the plaintiff to mark those documents as exhibits in their evidence. The said application was registered and numbered as Ms. Z case number 302/2023. It is against, it is under such circumstances, CRPIO number 82/2025 was filed. Mr. A. Sahad, the learned counsel appearing on behalf of the petitioner, petitioner had submitted that the learned trial court had exercised a jurisdiction not vested upon it on law in view of the fact that a stranger was permitted to file such applications in the suit. This court is of the opinion that the said submission is totally misconceived, inasmuch as the first application so filed, which led to the filing of CRP IO 69/2025, is essentially an application under Order 22, Rule 10 of the Code, though 22:10 of the Code. And as such, the learned trial court was justified in showing the representation of the plaintiff now through the respondent number 5, who is the present General Secretary. As regards the application filed under Order 7, Rule 14, by which the plaintiff sought leave to bring on record 2 documents, this court is of the opinion that the said court, that the learned trial court had the power to grant the leave in terms with Order 7, Rule 14(3) of the Code, and accordingly, this court finds no jurisdictional error in exercise of its jurisdiction. The third application, which resulted in the filing of CRP IO 82/2025, was essentially an application under Order 11, Rule 14, thereby seeking appropriate directions upon the respondent, upon the petitioner herein, the defendant number 1, the petitioner herein, to produce certain documents. The learned trial court, taking into account that the said documents are essential for the purpose of adjudication of the issues involved, had passed appropriate directions by the impugn order dated 5/9/2024. The said, in the opinion of this court, does not constitute any error. Consequently, this court finds no merit in the 3 applications so filed, for which the same is dismissed with cause.
For admission item 4 or 3rd.
Anything happening?
Yes, sir. In fact, they have submitted a proposal. They have asked for time till end of this month. Probably it will be fast. And so far the caretaker is concerned, 350. They have already engaged one. Lordship is posted at the end of this month or in the first week of April.
Mr. B. Gogoi submits that appropriate steps have been taken in this regard and requests the matter be listed again on, we have it on, because I won't be here from 1st of April. Let's have it on 28th of March. 28th of
But
March.
it's not 28, I have some difficulty. My junior will be here.
Nothing.
She will not be-
Can you finish up, Mr. Because you see, she's doing it pro bono, so I don't trouble her more. How much trouble you are going to give to me? Madam,
12 years, it's all
I
right.
think
12 months
we
is fine.
need to put another head for paying to the council also. See that torturing. And this matter has to finish off. Yes, what is this?
Lordship,
Lunch. Yes,
It is your lordship. Lordship, the petitioner number 4 has already been died on 24 December, lordship.
Hmm.
I have filed a separate IA.
just come.
No, lordship. That has not been taken up.
Okay, it has been submitted that the petitioner number 4 had expired and as such appropriate application has been filed
Okay.
for substitution of the petitioner number 4. But however, the same is not on record. List this matter again on 24th of March, 24th of March 2025. Which of the registry shall bring on record the said interlocutory applications.
And we will have to substitute the legal errors also.
You have not filed that application.
I have filed a IA that my matter has been died, lordship.
The petitioner number 4 expired. Now,
I want to,
who petitioner number 4 is your mother?
yes, lordship.
Okay, and who, you are there?
Yes, I am.
You are
petitioner
number 5.
Yes, lordship.
You are number 5. So 4 is there. So your mother, how many sons and daughters are there?
Lordship, my elder brother has already been died, but my 2 elder sister is there.
Would they like to participate?
No, lordship.
They don't want to participate. So then, taking into account the 5 is there, you need not file any application. We can proceed by striking out the name of defendant as petitioner number 4 as her estate is duly represented.
Yes, lordship. I've already filed a strike for striking out.
And it's okay, we pass that order then. Mr. D. Borman, the petitioner in person, submits that his mother, who is the petitioner number 4, had died. And he can represent the estate of the petitioner number 4. Taking into account above, the name of the petitioner number 4 is struck off. It's struck off. Post. At least the matter on 24th of March 2025. Also, in the meantime, the counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 2 days. And on the basis of that, the registry shall make necessary corrections in the cause title of the petition of the instant proceeding, as well as update the same in the CIS.
Your blessing. Item 6 and 7.
Yes, what is this?
Well, it's a commercial suit, my lord. It was filed on 33/22. Then someone was issued, my lord. 6/4/22 was a report was silence of
What are you challenging?
well, challenging the order, my lord, by which, my lord, other order 9 rule 7, my lord, the petition was allowed.
Huh?
Order 9 rule 7.
Ex parte?
That's right. My lord. Yes,
You are challenging an ex parte order.
well, no, it has been set aside. Ex-parte order has been set aside.
Order 9 Rule 7.
Yes.
Isn't it the discretion of the trial court?
Hello?
Isn't it the discretion of the trial court?
Ingredients, my lord. There must be ingredients. It's a commercial suit. And he has allowed the other party to file WS. WS, my lord, time is limited 90 days.
That cannot.
Yes.
So it is a case where it is not a question of ex parte being vacated. It is a case where it is beyond the time.
If your
Now let us see the order where it is.
First, your lordship must see the petition, my lord.
First, let us see CRP IO 297 of the 2023.
Yes, that, my lord.
Page, which order you are
Petition is at page
challenging?
50, my lord.
Huh?
Petition is at page 50.
Page,
90, yes.
Mr.
No,
Which
I'm sorry,
order
my
are
lord.
you
I'm
challenging?
sorry, my lord. Page 13, huh?
Which order are you
Interim order
challenging?
is at, my lord, yes.
Huh?
Interim order is 63, my lord.
Page
Page 60,
60.
60.
I peruse the contents of the by the government and filed the AR for vacating the ex-parte order dated with permission to contest the suit by filing it in state. Ram saying. The purpose was let us summarize the events here. After the suit and regular.
There are 10 page 62 is the main.
Yes. So you supplied the copy on 111.
No, that is, my lord, for the other defendants. He is not a person, my lord. He said, my lord, if your lordship see,
You are against defendant number 1 and 6.
yes, 1 and 6, my lord.
1 and
1
6.
and 6, my lord, they have said that someone was served on 27/4/22, and ex-parte order was passed on 11/5/22. And they have not, my lord, they do not know about that ex-parte order till 8/12/22. This is their idea.
No, that is not the question.
Huh.
The question is, if you, the summons was served, it's okay.
Yes.
But they filed the petition.
Yes. They filed the petition when, my lord, that your lordship.
Whatever may be, they filed the petition.
Yes,
And the court passed an order,
yes.
thereby directing you to serve copies.
So in the other case, my lord, so far 2 to, my lord, 5 and others. So far, this is concerned, there is no nothing, my lord. If you also see the petition, that is no allegation. For this is concerned. They jumbled up, my lord, both the cases. So far, the other defendants are concerned. That is my.
Oh.
Because
I
here,
don't think this is a case for interference. See, let them file your affidavit.
have already
written
filed.
statement. Have you filed?
And that is accepted. Against that, they filed another petition. Second.
No.
my lord, they,
You see, you have gone to the commercial court for an early redressal of the matter. Very well. If it is the early redressal of the matter, then the court should have you let the suit proceed as early as possible. They have filed the written statement, let it be considered. Anyways, whatever may be, it is not a case where the court had said it has exercised its discretion. Why should I interfere under 2.7?
my lord, this by this order, not only yes, said ex-parte, but allowed to file written statement. My lord, written
Obviously, when he says that you have only served on the 1/11/2022,
No, not that, my lord. He was not there at that time. He said, my lord, your lordship see, this is the my petition. My lord, if your lordship see, he said that till 8/12, my lord, 8/12/22, he had no knowledge about the ex-parte order.
This is the case, my lord. He filed the petition on December, my lord. This petition was filed in December, 28th of December, 22. That is my grievance, my lord. He has mixed up, my lord, with the other defendants. Petition may be seen, my lord, your lordship.
Mr. Sahiwala, I'm not inclined to interfere in the 227.
My lord, only thing what I am submitting, this petition was filed on 28th day of December 22. So where the question of my lord 111, my lord, that does not, that is for other defendants. He has not made this grievance, my lord. This petition was page 48, my lord, the petition we've seen. It is 28th of December 22.
And when the defendant number 1 is duly represented by 225, they have already filed their written statement. And what
That would be, my lord. 1 to 6, my lord.
no. Go to Supreme Court. I'm not going to interfere these type of matters. No. This type of matters, if we interfere, then the suit is unnecessarily, these are matters pending from 2023. What heaven should have fall if the written statement is accepted and matter goes ahead? One has to think on the suit has to, only in exceptional circumstances. Yes, they made a mistake out there, but the court have exercised its discretion to allow it.
But I rely on this 1912, 210, my lord.
It says about that thing, in the case of AI, you cannot go beyond 120.
Yes, my lord.
120 days.
That the
That's
WS file, my lord, should be, my lord,
120
off the
days,
record.
but the fact that in respect to other defendants who appeared,
yes.
2 to 5, they serve copies upon them only on 111.
His, my lord,
Understood? It is you filed only on 111, meaning thereby that you have yourself to be at fault for the delay. Rightly? No. Therefore, Mr. J. N. Sahiwala, the learned counsel, appearing on behalf of the petitioner, assisted by Sir and Mr. D. Mojumdar, the learned counsel, appearing on behalf of senior counsel, assisted by Sir appearing on behalf of the respondent number 1 to 6. Both the petitions being CRP IO number 297/2023 and IO number 267, which is the second one.
Second one, my lord, that is
267.
267.
Second one is earlier.
Yes, this was earlier.
Numbering has been done.
Numbering has been done.
Challenging the orders dated past and this one. With the petition being applications being CRP IO number 267/2023 and CRP IO number 297/2023 are taken up together, taking into account that both arises out of the same suit. Because it is seen from the records that the petitioner herein as plaintiff had filed a suit being money suit number 87/2022. Before the court of the learned civil judge number 3, Amrup Metro at Guwahati. The said suit comes within the ambit of a commercial suit. In the said suit, it is seen that the
That depends on list of days. short list of. Again,
You will see that after the summons were issued, the learned commercial court passed an order on 11/5/2022 whereby on account of the defendant number 1 and 6 having not appeared in spite of the summons having been received, it was declared that the suit shall proceed ex parte against the defendant number 1 to 6. As regards the other defendants, as the summons were not served, the plaintiffs were directed to take steps upon the defendant numbers 2, 3, 4, 5, and 7. It is further seen that the defendant number 2 to 5 thereupon appeared on 11/8/2022 to the engaged counsel and filed a petition bearing petition number 2886, praying for directing the plaintiff to provide copies of the documents filed along with the plaint. The said petition was no order could be passed on the said petition on 11/8/2022, taking into account that the presiding officer of the court was not present. However, on 1/11/2022, the trial court, the learned trial court passed an order on another petition filed by the defendant numbers 2 to 5, being petition number 3904/2022, thereby directing the plaintiff to provide the copies of the documents to the defendant numbers 2 to 5. The learned trial court permitted the said application, allowed the said application, thereby directed the plaintiff to serve copies of the documents relied upon the plaint to the defendants and fixed 8/12/2022 for filing of the written statement. So it was noticed by the counsels who appeared on behalf of the defendant number 2 to 5 that it was noticed by the counsels appearing on behalf of the defendant numbers 2 to 5 that as regards the defendant number 1 and 6, the suit was proceeding ex parte on the basis of an order dated 11/5/2022. Accordingly, on this aspect was noticed on 8/12/2022. The matter was on 20/12/2022, the defendant numbers 2 to 4 filed their written statement. And on the very day, another application was filed by the defendant numbers 1 to 6, seeking vacation of the ex parte order. This application was the petitioner herein with the plaintiff filed objection to the said application. And the learned trial court by the order dated 3/6/2023 had allowed the said application. And it is under such circumstances, CRPIO number 297/2023 was filed. Subsequent thereto, on
3/6. Same deal, 3/6.
on
3/6 itself.
3/6.
The case was accepted.
Subsequent thereto, on 3/6/2023, the 3/6,
3/6.
after such a long time,
Malu filed it on 20th December. It was accepted on 3.
no, so you filed your written statement also for 1 and 6 also.
Yes.
on that date, on 2012.
20th December.
It is তার উপর আরো একটা line লিখিব, it is relevant এই এনেকা আহিব হা। It is not only defendant number 224, Mr. Majumdar. It is not only defendant number 224,
Yes.
but also 1 and 6.
Yes.
What about 5?
5. But all are in the same company, so even if someone doesn't sign, no problem.
এনেকে লেখক হা, অকমান আনিব হা, এইটো দিব, এইখন petitionখন file কৰিলে তো।
I-
এইখিনি report লিখিলো ন, that petition.
5 has got no connection with the company.
It came to the attention of the counsels who were appearing on behalf of the defendant number 225. We were also representing the defendant numbers 1 to 6. Subsequent, that the suit was proceeding ex parte against the defendant number 1 to 6 by an order dated 11/5/2022. This aspect came into light on 8/12/2022. On the same date, the defendant number 2 to 4 had filed their affidavit written statement. The defendant numbers 1 and 6 also filed their written statement along with another application under Order 9 Rule 7 for vacating the ex parte order. This petition, which was filed under Order 9 Rule 7, to the said application filed under Order 9 Rule 7, the petitioner herein, who was the plaintiff, filed written objection. The learned trial court passed 2 orders on 3/6/2023. The first order is being passed on the application under Order 9 Rule 7. That is Mize case number 1168/2022, whereby the application under Order 9 Rule 7 was allowed. The second order which was passed was
And another other orders.
accepting the written statement of the defendant number 1 to 6.
1 and 6.
1 and 6, which is the subject matter of challenge in WPC CRPIO number 267/2023. This court heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Mr. G. and Sahavala, the learned senior counsel, submitted that the law is well settled that for the purpose of filing of the written statement in a commercial suit, the trial court cannot permit more than 120 days. In that regard, he referred to the judgment of the Supreme Court in the case of
SCT contracts. Well,
in the case of SCG Contracts Limited, Contracts bracket India bracket P Limited versus KS Sharma CHAMANKAR Infrastructure P Limited, reported in 2019, 12 SCC 210. He therefore submitted that as the summons was duly served, as was held by the learned trial court, in its order dated 11/5/2022, the learned trial court would not have vacated the ex parte order and accepted the written statement on 3/6/2023. He therefore submits that this aspect goes completely contrary to the provisions of Order 8, Rule 1, as amended for suits relating to commercial disputes in terms with the Commercial Courts Act
2015.
The Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015.
Well, that was earlier name, by the way.
Now what is the name?
The Commercial Courts Act 2015.
Commercial?
Courts Act 2015.
Commercial Courts Act 2016.
15,
15 or 16?
15.
You sure?
Yes, yes, I have got a copy of that. Commercial code.
Show me. I'm not a commercial court judge, so therefore.
Act of 2016. But the name of the act is Commercial Code Act 2016.
Now here they mention about Commercial Courts Act 2016. That is why I'm saying.
No, not correct.
Not correct.
Commercial Courts Act 2015. Just a- Per contra, the learned counsel appearing on behalf of the respondent submitted that the defendant number 1 to 6 are one to 6 and 1 to 7 are belongs to only the entity that is the defendant number 1 and are directors and officers of the defendant number 1. Who's- who's- He submitted that Yes, what is your submission?
Trial court has exercised its discretion, and here is the case where, as your lordship is given from the list of dates, the copies of all the same counsel is appearing. I did the argument. Same counsel is appearing for all the defendants. Now, on 8/12/22, they actually, matter of factually, London trial court has recorded for all the defendants, they filed the application asking for time. At that stage, when the counsel appearing for the plaintiff pointed out that no, you cannot file application on behalf of all. Why? There is already an ex-parte order against different number 1 and 6 on 11/5/2022. On that day, as the lordship has already mentioned, 8/12/22, for the first time, the counsel for all the defendants came to know that there is an ex-parte order. That is why they have filed application. Secondly, my lord, documents for all the plaintiff submitted the legible copy of the document only on 1/11/2022. And that is why the London trial court has recorded even if they had appeared, they could not file the written statement. Could not have filed the statement.
No, but what do you explain as regards non-appearance on 11/5?
11/5, my lord, actually, I have explained, my lord. 3 sets of one, the regular counsel was absent. He engaged another counsel. He engaged his colleague. So there was a communication. I have explained in the petition, and everything is there in the petition. So kindly look at the petition.
No, 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 no.
Madam.
I'm asking you
On
because,
11/5.
no, Mr. Majumdar, I'm asking you because being not satisfied with your explanation on 11/5 for not appearing, I'm asking.
Fine.
Otherwise, I was dictating.
Fine.
What is your explanation not to appear on 11/5?
My lord, Lordship, kindly.
There's nothing out there.
Well, the page 46, para 9. Eight and nine.
Para 9.
8 and 9.
46, my lord.
8 and 9.
8 also on the page 45.
Where is it?
Page 45. 45 and mainly page 46, para 9, man.
No, this is subsequent.
No,
Mr. Majumdar, you were supposed to appear on 11/5/2002 for defendant number 1 and 6.
Correct.
On that very date, you did not appear.
no.
Now, if you, on that date, the court exercised the power under Order 9, Rule 6A, thereby saying that the suit will proceed ex parte, and the question of filing a written statement does not arise. Now, thereupon, you have filed Order 9, Rule 7 for vacating. On the ground what? Why didn't, because you have to now put the clock back to 11/5. What is your ground for
I
that?
don't, I have to prove, as the lordship is saying, I have to prove good ground for my non-appearance on 11/5.
That is what you have to show that. Where you are pleading to the.
Page 46, para 9, lordship, kindly. And fairly they have submitted. The petitioner state that they failed to appear on 11/5/2022. Page 46, my lord. Failed to appear on 11/5/2022, partly due to misunderstanding and partly due to inadvertent error on the part of their counsel.
We allow it. We dismiss his petition. We allow Order 9, but impose a cost upon you of a lakh. This has to be done, and something serious. Mr. D. Mojumdar, the learned counsel, senior counsels further submitted that the defendants all along wanted to appear. But there was a misunderstanding. and a miscommunication with the counsels, which resulted in non-appearance on 11/5/2022 on behalf of the petitioner, on behalf of the defendant numbers 1 to 7, 1 and 6. He further submitted that the other defendants thereupon received the summons on 11/8/2022 and appeared before the learned trial court. He further submitted that when these documents, when the materials were placed before the learned trial court, that the summons were served with certain documents which were not legible. The learned trial court, by an order dated 1/11/2022, directed the plaintiff to serve legible copies of the documents which were relied upon to the plaintiff. He therefore submitted that in terms with Order 5, Rule 1, the requirement of summons, when a summons is required to be served, it includes not only the plaintiff as well as the documents relied upon. He further submitted that in the instant case, the counsels were not aware that the suit was proceeding ex parte against the defendant number 1 and 6. And as such, when it was realized on 8/12/2022, immediately on 20/12/2022, the application was filed under Order 9, Rule 7. And this application was allowed. He further submitted that along with the other defendants on 20/12/2022, the defendant number 1 and 6 has also filed their written statement. This court have also perused this court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The learned trial court, by the order dated 3/6/2023 in case number 1168/2022, had exercised its jurisdiction under Order 9, Rule 7 and came to an opinion that the defendant numbers 1 and 6 have been able to make out a good cause for putting the clock back to a good cause while explaining a good cause. For their previous non-appearance. And have accepted the written statement so filed by the defendant number 1 and 6 along with the 1 and 6. Taking into account that the learned trial court, taking into account that the defendant numbers 1, the defendant number 2 to 7 are employees of the defendant number 1. And there would be no, taking into account that the defendant number 2 to 7 are employees of the defendant number 1. And the defendant number 2 to 2, who is the managing director, have duly filed their written statement, which is being accepted. So, the proceeding of the suit ex parte against the defendant number 1 and 6 would not serve any purpose. In addition to that, this court is also of the opinion that when the learned trial court had exercised its discretion, in exercise discretion, it would not be proper on the part of this court under Article 2 to 7 of the court, 7 of the Constitution to exercise its supervisory jurisdiction. Be that as it may, it is the opinion of this court that a reading of Order 9 Rule 7 of the Code categorically mandates that that if a good cause is being shown, the learned court, on such terms as the court, on such terms, direct as to cause to otherwise permit, vacate the ex parte order. However, the learned trial court did not impose any terms or any costs while passing the order dated 3/6/2023. In the opinion of this court, that the certain cost ought to have been imposed upon the defendant number 1 and 6, taking into account that they have received the summons on 27/4/2022, and accordingly, or they ought to have appeared on 11/5/2022. Because taking into account the above, this court is not interfering, taking into account the overall facts and circumstances. This court is not interfering with the order dated 3/6/2023, passed in Mise case number 1168/2022, as well as also in commercial suit number, as well as also the order dated 3/6/2023 in commercial suit number 24/2022. However, this court imposes a cost of ₹1 lakh upon the defendant numbers 1 and 5, who are the respondent numbers 1 and 5 here, 1 and 6 herein. Defendant numbers 1 and 6, who are the respondent numbers 1 and 6 herein. And it shall be the condition precedent for that the said cost of ₹1 lakh is required to be deposited before the learned trial court on the next date so fixed by this court hereinafter. It is observed that the deposit of this 1 lakh shall be a condition precedent for the purpose of accepting the written statement of the defendant numbers 1 and 6. Taking into account that there is an order of stay passed by this court in CRP IO number 267 of the 2024-23. The said, there is an order of stay dated 28/8/2023, whereby the commercial suit number 24/2022 was stayed. This court, taking into account that all the parties herein are represented, they are directed to appear before the learned trial court on 7/4/2025. On the same date, as stated above, as observed and directed above, the defendant number 1 and 6 shall deposit the amount of ₹1 lakh imposed as cost. The petitioner herein, who are the plaintiffs, shall be at liberty to file an application before the learned trial court for release of the said order and the release of the said amount and the petitioner and the respondent and the learned trial court shall pass appropriate orders.
early disposal,
Huh?
early disposal.
I can't. Once you come back.
Regarding the cost only one submission line, they are also guilty of not subpartishing their document till 8/12. 1/11 also is seen. Subsequently on 8/12, they have admitted that we cannot.
Mr.
supply.
Mohinder, should I interfere with the order of 3/6?
No, I'm saying they are also guilty.
No, you want, I can, we will change it. Because you did not explain 11/5. And the learned
That is why I'm not saying anything.
Mr. Mohinder, I think we should impose 150. 2 lakhs.
Item 8.
2 lakhs. will do.
What the court have decided against me. That I am basically arguing on a very limited point. The area rent. That is at page number 69.
Yes,
If I agree that I have not fulfilled the provision of 5(2), but on the area
area and mean,
since May 2015, I have been paying the rent in court. The trial court as well as the appellate court says that I have been directed to pay the rent from May 2015. That is.
Huh?
Yes, in the last page. Page 77.
May 2015 till eviction.
Till eviction. Thus, I have been depositing the rent in court. I agree that I have not fulfilled the provision of 5(2). But if I am again directed to pay the rent from May 2015, I have to pay double. Otherwise, I am ready to vacate the tenant premises.
When?
If 5-6 months is granted, Lordship, I am ready to vacate the premises.
We do one thing. You will go for execution. As regards this, from May 2015, let him go. But while showing that, if you have deposited any amount before the court, the same shall be adjusted. You vacate when?
5-6 months, Lord.
When? Today is
Is Lordship 17.
17. Okay, you vacate on 30th of June. Heard Mr. G. Bhardwaj, the learned counsel appearing on behalf of the petitioner. Mr. N. The name?
My lord, I'm for the respondent, full respondent, Santosh Sarkar.
Mr. N. Deka
Endorsement.
Huh?
Endorsement.
appears on behalf of the respondent. Is an application filed under by invoking the revision and jurisdiction of this court under section 115 of the Code of Civil Procedure 1908, for short the code, challenging the judgment and decree dated January 12, 2024, passed in title appeal number 1/2023, whereby the judgment and decree by the Court of the Civil Judge hereinafter referred to as the First Appellate Court, whereby the judgment and decree dated 29/11/2022 passed by the Court of the Civil Judge Junior Division number 1, Kamrup Metro and Guwahati, hereinafter referred to as the Learned Trial Court in title suit number 112/2015, was confirmed. The question arises as to whether, in the present facts, this court is required to exercise its revisional jurisdiction. From the materials on record, to ascertain the said question, this court finds it relevant to note down the facts which led to the filing of the instant revision petition. There was a counterclaim.
Counterclaim.
That has been decreed, madam.
Huh?
It has been decreed.
The petitioner herein as plaintiff instituted a suit which was registered and numbered as title suit number 112/2015, seeking declaration that the petitioner is a tenant under the defendant, and for permanent injunction restraining the defendant from letting out the schedule suit room that is described in Schedule A to the plain to any other person. And for a declaration that the petitioner oblique the plaintiff shall not be dispossessed or evicted from the suit room without following the due procedure. For the sake of convenience, this court আগতে লিখিব হা এইটো নামটা দিয়াৰ আগতে ফাইল দ্য সুট বুলি লিখিছো নহয় তাৰ আগতে লিখিব For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. The plaintiff filed a suit being the petitioner as plaintiff has filed a suit being that is suit number 7 seeking suits. It is the case of the plaintiff that he had taken the suit room on rent initially at a monthly rent of rupees 900, and subsequently it was enhanced to rupees 1800 per month. He further stated that he had paid an amount of rupees 30,000 as advance to the defendant at the time of taking the room, which is yet to be adjusted. On 24/2/2014, the when the plaintiff opened the shutter to the suit room, he could find the entire materials inside the room were reduced to ashes in fire. The plaintiff alleged that it was committed by the defendant. Was apprehending that the defendant could possibly evict the plaintiff from the suit room. The suit was filed seeking for the declaration as referred to here in above. The defendant filed a written statement cum counterclaim, wherein the defendant raised the pleas that the plaintiff is a defaulter in payment of rent. It was mentioned that though there was an advance amount of rupees 30,000, but the said amount have already been adjusted till June 2014. It is the specific plea of the defendant that the plaintiff was a defaulter in payment of rent from the month of July 2014. On a question of Bonafide requirement, it was also mentioned in the written statement cum counterclaim that the said suit room was required for the children of the defendant who wants to carry out some business. On the basis of the said on the basis of the pleadings, the trial court framed as many as 6 issues, which being relevant are reproduced here in under page 41 of this. On the issue pertaining to Bonafide requirement, on the issue pertaining to default in payment of rent, the learned trial court held. Now, page 41, 42. On behalf of the plaintiff, he adduced himself as a witness and also exhibited various documents. On behalf of the defendant, there were 2 witnesses who were adduced. And the defendant also adduced certain documentary evidence. The learned trial court decreed the suit in favor of the plaintiff by judgment, decreed the suit, dismissed the suit of the plaintiff and decreed the counterclaim of the defendant. by the judgment and decree dated 29/11/2022. In doing so, the learned trial court decided the issue, decided, came to an opinion that the plaintiff was a defaulter in payment of rent in terms with Section 5(4) of the Assam Urban Area Rent Control Act 1972, for short, the Act of 1972. In addition to that, the learned trial court also came to a categorical opinion that the defendant had a bona fide requirement of the suit premises. Being agreed, an appeal was prepared, being titled Appeal Number 1 of the 2023 by the plaintiff. The said appeal was dismissed by the judgment and decree dated 12/1/2024, thereby upholding to the findings so arrived at by the learned trial court on the issue of defaulter in payment of rent, as well as also on bona fide requirement. It is under such circumstances the instant appeal has been prepared. Mr. G. Bhardwaj, the learned counsel, submits that taking into account the scope of the revisional jurisdiction, wherein the findings of facts cannot be interfered with unless there is a gross perversity, his submission would be limited to that the plaintiff, the petitioner herein, is ready and willing to vacate the suit premises. However, in doing so, premises, if within a particular span of time, as may be directed by this court, he further submits that the learned First Appellate Court had directed that the plaintiff has to pay rent on the month of May 2015 till his eviction. However, the learned trial court, the First Appellate Court, failed to consider that the plaintiff the petitioner have been depositing the rent in the court. He therefore submit that the directions for recovery of the rent from May 2015 till eviction has to be supplanted by a further direction to that effect, that the amount which have been already deposited by the plaintiff before the court should also be adjusted against the said payment, against the said recovery. Mr. Enders, the learned counsel, appearing on behalf of the respondent, submitted that the plaintiff have been, that the defendant have been seriously prejudiced on account of the on account of the seriously prejudiced, have been seriously prejudiced on account of the delay in the eviction proceedings. He therefore submits that the plaintiff may not be granted any time beyond a month. Taking into account the above submissions, this court have duly taken note of the submission and have also perused the lower court records, the trial court records, as well as the appellate court records. From the materials on record, including the evidence, this court is of the opinion that the question of exercising the revisional jurisdiction in respect to the finding of fact that the plaintiff is a defaulter in payment of rent and the defendant has bona fide requirement of the suit premises do not call for any interference. This court further takes note of that the plaintiff is presently carrying on some business, and as such, to throw the and as such, to direct the petitioner to vacate immediately would have far-reaching consequences would cause irretrievable injury. Considering the above, this court directs this court, considering the above and the submission of Mr. G. Bhardwaj, the learned counsel appearing on behalf of the petitioner, This court permits the petitioner to retain possession of the suit premises till 30th of June 2025. So during this process, the defendant, the plaintiff the petitioner shall remain in possession of the suit premises as a custodian of the plaintiff and shall not take any action which would be detrimental to the interest of the defendant. Custodian of the defendant and shall not take any action which will be detrimental to the interest of the defendant. During this, it is further directed that during this period, the plaintiff shall also pay in the form of compensation an amount of rupees. What are you paying now?
1,800.
An amount of rupees 1,800 to the defendant, which under no circumstances shall create any landlord-tenant relationship between the plaintiff and the defendant. This court further directs that in order that for the purpose of getting the benefit to remain in possession of the suit premises till 30th of June 2025, as observed herein above, the plaintiff would be required to submit an undertaking within 10 days from today before the learned trial court, that is the court of the so-and-so, to the effect that he would vacate the suit premises on or before 30th of June 2025, that he would be regularly paying the amount of rupees 1,800 per month as compensation, that he would not engage in any activities which would be detrimental to the interest of the defendant over the suit room. It is observed that if the said undertaking is not given within a period of 10 days from today, as observed above, the plaintiff would be at liberty to proceed with the execution of the said decree.
1,500 plus electricity charges.
Huh?
1,500 plus
Plus
electricity.
other electricity charges.
And my lord, there are two appeals has been filed. One against the dismissal of the suit against the contractor. Both are dismissed. Both the appeals are dismissed against the preferred revision.
So far the area rent is question.
Oh, this court further observes that the plaintiff herein would be entitled to carry out the execution in respect to the area rents. It is, however, observed that while carrying out this area rent, while executing the area rent, the executing court, this further observed that this court further observed that the defendant would be entitled to the rent for the period from the rent would be entitled to the rent for which the suit was filed, as well as for the rents during the pendency of the suit till date. For that, the defendant can very well file an application before the executing court. The executing court, while executing the said decree as regards the recovery of the rent, shall also take note of the amounts which have been deposited by the plaintiff before the court, and on the basis thereof pass appropriate directions.
Item 9.
Yes.
Paid for this case along with another CRPI is pending. Same petitioner here, same parties.
What is this case about?
This case, I have filed a petition for accepting my documents before the learned trial court. It was rejected. And another case filed by amendment of the WS, and it was also rejected same day. And with the petitioner being the defendant has filed two CRPI. And it's pending.
Disorder? Order of 7/5/2019.
No, Your Lordship.
Huh?
2/3/2024, page 63. Same date, petition is rejected.
What is this order? Order 11/14.
Page 63 and access 5.
What did you ask for?
Some documents we have submitted and we have not any earlier submitted, but as this petitioner accepted the documents,
You are the defendant.
dependent,
You have not adduced evidence till now.
we didn't submit it, but we have not presented.
So you wanted some production of certain documents.
Already it is on record. It is on record.
You wanted the originals to be produced.
Is the same date and so on. And we also
You
find
are
that
asking this document to be produced from where?
we accepting the documents. Your Lordship.
Who has the documents?
Documents, Your Lordship, sell it and some report of the register and Jamabanti copy. Then
From where?
it's already on record. We have already submitted it.
Then what do you want from this
But it is not
application?
accepted, Your Lordship. Because initially it is not submitted, Your Lordship, at the time of WS payment issue. And subsequently it is submitted at the time of.
Evidence. So you filed an application on the order 8/183. What
But
is it?
initially, they had filed an application in the year 2019 that my lord will find at page number 63, 2019, for seeking the same leave, my lord, to produce the same documents. That application was rejected. Thereafter, my lord, they filed DW1, DW2, and DW3. Along with DW1, they filed those documents, my lord. Same deed, unregistered same deeds, copy of Jamabandia. And so we filed an application, my lord, under order 11 rule, under order 13 rule 7(2), saying that, my lord, since these documents are not admissible and since these documents have not been produced without the leave of the court, so it should be returned back to them. That application was also allowed. Subsequently, my lord, they filed this application saying that they want to produce these documents. Now, what documents they have not stated in the petition, my lord? If my lord goes to the petition, my lord, those documents they have stated, but what documents?
Where is the petition?
Petition, Your Lordship, they stick here.
Page
50, 50.
What documents are these?
So it is not mentioned, it is, but the document is held it. And what
Where is it mentioned?
it is not mentioned, Your Lordship. But
Then-
already at the time of evidence, it is submitted before the court.
No, but are you not required to mention?
It is required, Your Lordship, but it is a mistake of the advocate.
Did you seek for leave under order 8/183? Are you filing under order 11/14? The documents are with you.
Documents already at the time of evidence, it is submitted before the court.
Understood, Mr. Islam. The
But it is-
question is
it is
why
a
you are
long-
seeking leave?
But
You are required to seek the leave. That
Leave
these
the-
documents I had that to be produced for, these are the reasons, so kindly allow me. And that petition was filed earlier. And that was rejected, isn't it?
yes, sir, it is.
Then,
It is filed earlier.
then why
But
haven't you
without
challenged
leave
that?
of the court, it is filed. That is the. I asked to return.
Have you challenged that order?
No, Your Lordship. This.
File an additional affidavit. Challenging, bringing on record that order.
That or I will not record here. Already record here.
Where?
Page 63, my lord.
Page,
63.
45, Your Lordship.
page 45.
45.
This is their petition.
That is our petition. 63 is their petition where they sought for the leave. Page 63. My lord,
45,
page
Your Lordship.
69, my lord.
That's earlier.
Operating portion is at page 76, para 31.
Is it mentioned in your pleadings about those documents? In your plain? In your written statement, have you mentioned anything about those documents? Huh? Mr. Islam, you seem to be not aware. We do one thing, we vacate this order, we go and prepare it. The counsel appearing on behalf of the petitioner seems to be unaware of the material, unaware of the case when the matter is taken up. Consequently, is the matter after 2 weeks.
Stay order is there, madam. The suit is
Huh?
pending. There is stay order.
I'm not extending the order.
Item 10.
We expect better things, Mr. Islam. Don't appear before the court unfair. I'll do that. Mr. Arba Pujari appearing on behalf of the petitioner, Finance Department submits that the affidavit. Oh, Mr. Arba Pujari, where is he? He asked for time, but earlier I had given him one more opportunity. How many times he requires?
Was here. Otherwise, Lordship, that recovery amount, Lordship, I have been told that it has been stopped due to some technical difficulty, Lordship. Let it remain like that, Lordship. It was stopped, Lordship, that recovery amount, Lordship, which was sought to be recovered at the rate of 5,000 per month. That was stopped.
Why?
Lordship, they said that it was due to some technical difficulty on their part. I don't know how, Lordship, but then the amount has not been fully recovered, Lordship, till then. And there are chances that it would be recovered again, Lordship.
It should be recovered.
No, Lordship, because
Why not?
the petition was made by the Dismissal session that
So what? Fixation, they have made it wrongly. So
those are receiving at a higher scale.
if they have stopped me, you should go ahead and recover. You see, later on he'll say that I'm about to retire. Then you can't. Rafiq Masi comes into the picture.
Yes, sir.
You can't get more than what it is.
No, Lordship,
Unless you show that your entitlement is to that more. Very well. But if it is a wrong fixation made by them, some official out there, it would not give you a right to recover, right to retain it.
no, it was not a wrong petition, Lordship.
So show me that.
Lordship, at page 51, the petition was made, Lordship. This page 51.
Page 51. Yes.
This was the fixation. Basic pay, rupees 20,000, 590 plus grade pay of 7,400 dollars. So this was with effect from the date she joined the office, Lordship. And what they did was that, Lordship, page 42. This is the pay slip of May. Herein at the left-hand side topmost corner, Lordship, therein the pay was reduced from that amount of 20,000 something to 15,320, Lordship. So that was the wrong made, Lordship. But the grade pay remained the same, Lordship. In the pay scale, they made an anomaly, Lordship.
You were first appointed here.
I was appointed in, I joined in 2016 itself, Lordship. But
Okay.
then, till April, in April 2018, I was paid before Lordship, page 41.
Now why they have reduced it? There must be good reasons.
Lordship, at that point of time, I was saying that the treasury objected to that pay scale.
So you should have been under 14,000 plus 7,400.
14. No, Lordship, page,
The issue involved out here is that you became later on.
yes, Lord.
You were appointed after 1/4/2016. So therefore, your scale of pay should have been, you should have been in the scale of pay of 14,000 plus 7,400.
This was stated by the Honorable Body Agod itself at page 45 to be in the pay scale of 20,590, Lord. Not 14,000, Lordship. That page 49 will clarify it, Lordship.
This is a letter you have written. I'm not on that. But the question is, when you were appointed, you cannot get more than that.
Lordship, the initial fixation has to be in the starting has to be in the pay scale of 20,590 and not in 14,000, Lord. That is the anomaly, Lord. And they have done it as 14,000.
No, you were appointed after 1/4/2016. So your pay scale has to be in terms of the stenographer grade 3,
Lordship.
isn't it? So stenographer grade 3, as per the ROP, what was the amount
Lordship,
after this?
the fixation was made by the court, this court.
Mr.
Yes, Lord.
Sharma, you are not understanding.
The pay scale.
The High Court has no business to give any more amount than what you can get. The High Court cannot give you more money. High Court doesn't have
I know
money.
that, Lordship. The
Money has
payment
to
is,
come from the state government.
the payment is of 14,000 to 49,000, Lordship. Payment is that, Lordship. But the initial fixation has to be at 20,590. So-
Why?
Because this was found at page 49, Lordship, will see, Lordship. This is the table, Lordship, as per which the fixation was made.
Here, what is this?
Lordship, at serial number 10, Lordship.
Hmm.
At the right hand side, Lordship will see that starts at 14,000, that scale, Lordship. And at serial number 10, it's 20,590. That was the initial pay which was to be fixed, Lordship.
Hmm.
So it has to start from that pay, Lordship. And subsequently.
Why this pay?
Lordship, because that was ascertained by the High Court itself, Lordship, in terms of page 49, Lordship. They gave some reasoning, maybe in the resolution, Lordship, but what was the outcome is at page 48, Lordship.
48.
Right.
Initial fee release fee.
The last one, Lordship. The modified table,
You were,
6.8.
no. You, in 2016,
Lordship.
2016, you were appointed on the basis of some direct recruitment.
Yes.
Isn't it? Now, you were appointed against some advertisement. What was the advertisement?
The advertisement, it's at page 29, now,
Page
29. The fourth line, the pay scale was given, Lordship.
5,200 dash 20,200 plus GP of so and so,
That was
PB2,
unrevised.
PB2. This happened in 2015.
Yes,
Then in pursuance to that, you applied
yes, Lordship.
and you got it.
Lordship, initially there was no anomaly, Lordship. I was to be posted somewhere else, Lordship. Then they revised that.
No, you
But
were
after that-
initially appointed in the year provisionally select and recommend for appointment. That is of 30th of July 2016.
Lordship.
Okay, then where's your appointment order?
Lordship, at page
Partial
38, Lordship, you'll find that.
modification
I was trying at
the
by
earlier
Lordship, then it
transfer.
was modified to.
Where's your appointment order? This one. Annexure 5.
Yes, yes, Lord.
newly created posts. Now, these posts now corresponds to 14,000 by 14,000 to 42,000 with payment GP of 7,400.
Yes.
Now, why you are putting this table at 49 at this amount?
Lordship, page 49, 48 will clarify it, Lordship, because it specifically relates to that stenographer's grade fee which were appointed during the year 2016. Subject part, Lordship will see that. And the fixation at the right hand side bottom, at the end, Lordship will find that modified table number 6.8.10. This is the table referred to here.
GP of 7,400. Anyways, finance has not filed affidavit, we should allow your petition. What do you say?
On 20th of October last year, there was a direction. Report. Please, notification appearing in page 68 of 53. That has come. The two notifications, primarily for the same.
No, I don't understand what is the basis on which the finance department is saying. It should say 15,000 plus 21,000. This is page 66. They are enjoying an interim order. So they are deducting.
With effect from March, Lordship, the deduction is not there. It was said that due to some technical difficulty, they could not deduct it, but then they will deduct it further when the technical difficulty is resolved.
You were not given an opportunity.
Only notice was served upon me prior to this deduction.
We will pass order, huh? Let Mr. R. Bapujari come. Ask him to come. Because he mentioned it in the morning. But he did not say that in this matter, I have granted twice opportunity to him on 27/1 as well as on 14/2. And this court further mentioned that the finance department shall file the affidavit without fail. So under such circumstances, we think we'll impose a cost of rupees 1 lakh, which will commensurate with the amount deducted from you for the time being. Today is the date of imposing costs, something like that.
Item 11.
Yes, what are you challenging?
The claimant was the elder brother of the deceased, who was a workman. Under this is an appeal under the WC Act. As per section 21D, he doesn't fall into the category of dependents. Lordship, 21D says the wife, minor son, unmarried daughter, and a mother are the only primary claimants. And if there's some other relatives who are dependent or older, even that does not include a brother. Even the son, Lordship, after he crosses 18 years and is infirm, then only that son is considered. Proceed means is, in this case, Lordship, the claim petition reveals the paragraph number 3 of my memo. The deceased was the son of late Thanaurong, and the claimant is the son of Nagar, not even brother, Lordship. Some distant cousin or uncle it may have. Not even brother. Claim petition first page reveals. This is not maintainable. As per Lordship, section 488 of the EL. Sub.
Take on negotiation.
It says, if there is no
Employees.
dependent, the employer doesn't have to pay. Section 8, subsection. So this is the case. He was a bachelor.
Did you raise this issue?
Yes, sir. Para number 12. May I read out Lordship? They are with me. I will do it now. That the claimants were not dependent upon the deceased. That right and title of the claimants are disputed. The claimant is required to submit a legal aid certificate issued by the competent authority. Failing which the claim petition is liable to be dismissed. This was the majority.
Wait.
That is not discussed there. I have the written statement. The judgment has not taken this point into consideration.
So it is not there in the judgment.
Judgment has taken other points, but this particular point,
So what is your,
which is not maintainable because
so your
it's not a-
substantial questions of law?
Yes, Lordship, I have framed it. Page 6 of my memo. Also.
That is the only ground?
It's the only go. They are not even they're not at any compensation. Section 210. One says there are 4 claimants primary.
2-1D.
1D.
What is it? Dependent.
Dependent. Brother is not in the picture at all.
Minor brother is there.
Minor, it is 42 years old. With wife and 17-year-old daughter.
But Mr. I would submit the learned counsel appealing on behalf of the appellant. Can appeal filed under section 23. Appeal under section 30 of the Employees Compensation Act 1923. Challenging the judgment and order dated 4/1/2025 passed by the learned commissioner for Employees Compensation Gulaghat in EC case number 19 of 2022. Which of the present appeal is admitted on the following substantial question of law. Whether the learned commissioner employees compensation was justified in awarding the compensation to the claimant. Whether the learned commissioner employees compensation was justified in awarding the compensation in favor of the claimant without taking into consideration the definition of dependent defined in section 2(1)(d) of the Employees Compensation Act 1923. All for the record, steps be taken upon the respondent by way of registered as well as usage. I state on the behalf. This is an application filed under Order 41, Rule 5 of the Code of Civil Procedure, 1908, seeking stay of the judgment and order dated 4/1/2025 passed by the Learned Commissioner for Employees Compensation Golaghat in EC case number 19/2022. Was issue notice making it returnable. Issue notice upon the respond number one is okay. We don't require for two. Here, I think for the stay,
Only
it is on the one.
one is okay, owner is not concerned.
Issue notice upon the respondent number one. This court is not inclined to issue notice upon the respondent number two in the present application. Issue notice returnable on the respondent number one, returnable on 5th of May 2025. Steps be taken by way of registered as well as usual upon the respondent number one. This court is not inclined to issue notice in the instant application as against the respondent number two. I've heard Mr. Arbusami, the learned counsel, appearing on behalf of the appellant insurance company, who submitted that the claimant was a brother. The claimant had claimed himself to be a brother, but taking into account that he was not even taking into account the definition of section 2(1)(d) of the Employees Compensation Act 1923, he would not come within the ambit of a dependent to file a claim proceedings in respect against the death of the deceased. He further submitted that this very aspect of the matter was duly taken into consideration, duly taken up in the this very aspect was duly pleaded in the written statement filed by the appellant insurance company before the learned tribunal below. But the learned tribunal completely but the learned tribunal did not take into consideration that same aspect. He therefore submitted that in the absence of a dependent approaching the court, the entire proceedings was not maintainable. He therefore submitted that the impugned judgment and order dated 4/1/2025 passed in EC case number 19/2022 is required to be stayed pending disposal of the appeal, which from this court have already admitted the appeal by formulating a substantial question of law. This court is further of the opinion that is prima facie of the opinion that the learned tribunal ought to have taken into consideration as to whether the claimant was a dependent in terms of section 2(1)(d) of the Act of the Employees Compensation Act 1923 before passing the said award. Consequently, this court in the next state states the impugned judgment and decree dated further past insurance.
Well,
Where please, your lordship, this application for modification of judgment and order dated 27/11/2024 passed by the learned claim tribunal. So lordship,
Where are your substantial question of law? Where are your substantial questions of law?
lordship, this is only for modification of the
Oh, this is railway.
railway.
Oh, railway. What do you want?
Lordship, withdraw the amount. All the amount has been fixed deposited. Your lordship, the railway claim tribunal has awarded an amount of 8 lakh to the appellants. Your lordship may kindly go to
How
page number
much?
17.
How much amount has been given?
8 lakh,
8 lakh.
8 lakhs.
Ah.
Of that, your lordship, the wife of the deceased has been awarded an amount of 4 lakhs. Of that 4 lakhs, only 1 lakh has been transferred to her saving bank account and 3 lakhs have been fixed deposited. And of the appellant number 2, that is son of the deceased, entire amount 1 lakh has been fixed deposited. And of the daughter of the deceased, entire amount 1 lakh has been fixed deposited. And of the minor son, 2 lakh have been fixed deposited.
then, for the, for the appellant number 1, 2, and 3, for the wife of the deceased, she is a weak and she required frequent medical care, and also they are unemployed. The son is the,
How will I know? Have you approached the tribunal on this?
yes, the tribunal has awarded the amount, but
No, then did you ask?
here,
This is being done in terms in Nanjapa. That is giving some fixed deposit and all these things. Now, have you approached the tribunal of this? Look here, that this is it. We require this money, kindly give it to us. No. Then you are not challenging on merit. You are coming before this court as regards the modification that this amount should be allowed to be released. Why have you not approached the tribunal?
tribunal has already awarded the order.
Understood. In MACT cases, normally it is being given. But this court is not going to exercise that power. Why should this court exercise? Because we have not approached.
Your Worship, similar order has been passed. Similar order has been passed.
So similar order passed has been passed, but that person has become major then. There was a mistake committed to the effect that these people were major. Kindly see that order. It's paragraph 6. We heard the learned counsel and also considering the facts of especially the submission of Mr. Bhagwat that all the appellants are major. And the direction was given by so and so to deposit in respect that has caused inconvenience. This court is inclined to allow the appeal by directing the learned tribunal entire amount in favor of the appellant. Then how is it possible?
Your Worship, only one is minor here, but other are major, and they are unemployed, and they require,
Total marriage.
daughter not married, for the marriage.
So
for the-
what will happen to a marriage? Huh? Daughter not married. Son
Son not married, unemployed.
is minor son
One is minor, Your Worship.
and the other is major. Why does he want that 1 lakh?
The 1 lakh to start a business. Start a business.
Go there. File an application. And then it will be. If they don't do, come under 227. See, by this way, what will happen? I will have to admit the appeal. The moment I admit the appeal, it will go for a 6. Get the point? I get the jurisdiction when I admit the appeal. I can't issue notice. Either I have to dispose of now or do. But for me to dispose of, I don't know anything. So you file your application that this is required, so kindly release this. I can pass a direction to the effect.
Yes.
Better off. Because if I admit the appeal, it will go finish. These people will all, the minor one will become major. Then we will get something. Don't you think so?
Minor,
The minor will become major by the time the matter is taken up.
oh, yeah.
Yes. Look. The present appeal has been filed challenging the judgment and order dated 27/11/2024 passed by the Railway Claims Tribunal, Guwahati Bench in OA bracket Roman 2 U oblique bracket close oblique GHY oblique 48 oblique 2024, whereby an amount of rupees 8 lakhs was awarded as the compensation along with interest at the rate of 6% from the date of the accident till the date of the order. And what is the future interest?
6%.
What future interest? In addition to that, it was further mentioned that if the amount is so not deposited within 91 days from the date of the said order passed in the claim proceedings, interest at the rate of 9% shall accrue up to the date of payment. The learned counsel appearing on behalf of the appellant, who are the claimant, submits that they are not aggrieved with the amount of compensation so awarded. However, the appellants herein are aggrieved at the directions given to the effect that the amounts which were awarded would be kept in fixed deposits. Fixed deposit. The learned counsel submits that this amount is very much essential to the claimants for the purpose of survival as well as carrying on of some business, and more particularly in respect to the appellants numbers 1, 2, and 3. So he therefore submitted that the order dated, the order impugned dated 27/11/2024 is required to be modified. So this court inquired with the learned counsel appearing on behalf of the appellant as to whether any such application is being filed before the learned tribunal, inasmuch as that would require some consideration of, as it require certain consideration on the facts. The learned counsel submits that no such application is being filed in that regard before the learned tribunal. So, taking into account the above, this court is not inclined to entertain the appeal, as the appeal only relates to the mode of disbursement of the amount. However, this court grants the liberty to the appellants to file appropriate application before the Railway Claims Tribunal, seeking modification as regards the manner of disbursement of the said amount by stating the facts for which such modification is required. It is observed that in the circumstance such application is being filed, the learned tribunal, Railway Claims Tribunal, learned member, Judicial Railway Claims Tribunal, shall duly consider the same on the extent facts and pass appropriate orders. It is, however, observed that if the petitioner appellants thereupon is aggrieved, they would be at liberty to approach this court. That will be helpful. Otherwise, if I admit, finish.
13.
Your lordship,
Ah,
I'm on very weak
weak
grounds.
ground, I think we
I
should.
have failed to defend myself. But on the other, only small point that I want to make,
In this case, the claimant also failed to substantiate his case. His primary case does not stand on its own. Like Lordship, in this case, it's a small award, Lordship. Now,
What?
just to raise a point, only this appeal has been filed. It's
Not-
1,72,000.
Point on, it's a death or injury?
It's an injury case.
Injury.
Small injury case. What happened is a small Tata Ace vehicle. He claimed to be carrying vegetables on the and traveling as the owner of goods. But he did not adduce any oral or he has no oral or documentary evidence who said that he was even doing the business of vegetables or even carrying vegetables in that particular day. That makes him a gratuitous present. The owner had appeared, owner also did not support that particular statement that he was carrying vegetables in my way. So there was, in my opinion, there's a failure on the part of it. Not just me, I don't,
CW1 is the claimant.
Is it?
Has stated in his evidence that on 20 he was carrying vegetables from Ambagaon, Nagaon to Tezpur by a vehicle bearing Iman. On a way, when the vehicle reached radio center Iman, the vehicle ran in excessive speed and turned upside down. As a result of it, he sustained injuries. He was immediately admitted Iman, then he was admitted to an accident took place due to rational exhibited Form 54 FIR medical report. Medical report is there.
I'm not disputing the accident or his injury. His status.
It's
His status, whether he was a bona fide occupant of the vehicle or a gratuitous passenger. In a small Tata Ace vehicle, not it is a small vehicle, Tata Ace vehicle, carrying goods, basically primarily for carrying goods. He did not prove his case by proving that he was a vegetable vendor. There's no witness, oral witness, or even documentary.
no, the fact that he had an accident.
Yes, that's that.
That is not a question.
That's
But the fact that you have not proved that there were more than these persons, the gratuitous, yeah, it is your burden to prove.
I failed in my mind. But I have failed.
Why?
But then primarily he also has a duty to
How can he prove that
make
I am
his
not a
case
gratuitous?
stand on legs.
I am a gratuitous passenger. Why will he prove?
Do that.
He cannot, he need not. That is your plea.
No.
And did you raise that plea at all?
Not that plea also. I have not taken that plea also.
Yeah.
But
In fact, day before yesterday, I was going through one
Not
judgment.
my point is that even he failed to make his case stand on legs.
No, he
He
was
did not
there, accident,
prove
his
that he was
name
a
was there,
physical
charge
matter.
sheet was there, everything is.
Or that
No case, I
that
think,
it does not show any seized goods.
no ground. Order 41, Rule 11 has to be invoked. To dismiss.
I leave it. I just wanted to make a point that whether a claimant also has to, there's a need for the claimant to prove his case.
Click on them. No, dismissed. Order given.
How like that?
He deposited, if you have not deposited it, deposit it within 6 weeks.
Already admitted, Lordship. That the permit defense was there, Lordship. Permit defense is there, Lordship. Connected cases have been admitted, Lordship.
Analogous case. So only the analogous case has already been admitted for the full payment only less that 10,000 of loss of amenities in life along with the interest in 9%.
Here, there is no loss of amenity, na?
Yes, sir. 10,000 is there.
10,000. So minus 10,000. So 85,000 you have to deposit. Two salary, na?
190.
80,000. আৰু এইটো কৈ দিব take the same incident na
Same
take this matter along with MAC appeal number 80 of 2020.
Payment may can be allowed.
Same order.
Yes. But the connected meter one should approve it.
This court grants the liberty to the claimants to file application before the registry, and upon such application, the registry shall after the release release the said amount to the claimant. Claimant hole claimant হবে দেই দুটা বেলেগ বেলেগ হব নালাগে ইয়াত আপোনাৰ এই অৰ্ডাৰটো ওপৰত claimant হ'ব তলত claimant হ'ব careful I dispose এইখন এয়া কৰি দিব and it will be 85,000 not 90. Appeal to admit to it. Yes, Mr. Barbudari, why haven't you told me that you have been given 2 chances earlier and today was the last chance?
Yes, madam. Now,
We will presume that the finance would not file an affidavit. No affidavit.
it's also a embarrassing situation for me, asking time again and again. So although I have received a written communication, so their authorities are praying for further 2 weeks time, madam. And just now I have talked with the deputy secretary. They are preparing it. Otherwise, my lord, we will be speaking, my lord, that the stand taken in, my lord, page 66. That I have, my lord, spoken with my department.
Yeah.
Page 66, because here the issue has sprung up, because, my lord, the employer is now seeking to deduct the excess amount of salary drawn by the petitioner. And it was, my lord, erroneously, my lord, fixed at that point of time. Now, that position, to that extent, my lord, the learned district judge had made a communication which lordship will find at page 54. Kindly see page 54. This is a communication from the employer to the finance department seeking clarification regarding initial fixation of salary of stenographer grade 3. And relevant portion lordship will find at the next page. Here lordship will find, though the aforesaid steno grade 3s are covered by ROP 2017, the difference in their basic pay was found as below. The basic pay of steno grade 3 who were appointed after 1/4/2016 but before publication of so and so. ROP 27,990. The basic pay of stenographer who were appointed after publication 22,050. Hence, the difference in their basic pay at the rate of rupees 5,940, though all are holding the same category of posts under the same pay band with same grade pay and covered by the same ROP. Now, what has happened here, my lord, prior to giving effect of ROP 2017, the grade pay was, my lord, at a higher stage. After it was given effective, it came down. So, my lord, at that initial point of time, my lord, she was erroneously given grade pay of the, my lord, pre-revised grade pay, which on the strength of, my lord, the sixth pay commission, that is ROP 2010. Now, this position has been clarified, my lord, by the finance department, which lordship will find at page 66. It is, my lord, a reply to that letter, which lordship has just now seen, my lord. To the district and session, the subject clarification regarding initial fixation of salary of stenographer grade 3. Your letter dated 12. With reference to the above, I am directed to state that as OM number so and so dated so and so, the government in finance PRU department increased the minimum pay in payment of 15 grade pays and refixed the pay of government servant who enters into service on or after 4/2/2010 by multiplying the minimum of pay in the pre-revised pay scale. The above mentioned pays were only meant for the directly recruited post. In the said OM dated so and so, pre-revise has not been included. So this was the error committed by the employer. Again, these stenographers grade 3 were recruited after the date of effect of Assam Service Division of Pay Rules 2017, that is 1/4/2016. As such, their pay is to be fixed as per Assam Service Division of Pay Rules 2017. That is, pay in the pay band plus grade pay, that is rupees 14,000 plus 7,400. It comes to minus rupees 21,400.
So 14,000 is the initial pay.
Yes.
Because the pay band starts from 14,000 to 42,000.
Yes.
So he has to get 14,000 plus the grade pay.
Great, great. And while they were appointed, they were selected, of course, for a valid selection process, they came to be appointed. The initial phase, my lord, that were given granted to them, my lord, was of this differential amount. This was the error, my lord, committed by the employers.
Now, Mr. Sharma refers to this particular at page 49.
Page 49.
And he refers to number 10.
Pay the pay after 3% increment. Then 10,610, my lord, it will be grade pay of 10,610. My lord, then the grade pay, revised grade pay also will find total pay is my lord 27,990 and 20,590. But this will not be applicable for the petitioner.
Because his grade pay is 7,400.
Yes, and in the advertisement also, Lordship will kindly see, my lord, the advertisement at page 29.
But at serial number 1,
Yes.
it is 14,000 is the pay band.
Yes.
And the grade pay is 8,100. It comes to 21,400.
Yes.
It is something is wrong here. Don't you think so?
My lord,
Something is wrong here. 14,000 plus 7,400 is 21,400.
14,000, yes, 21,400.
No, kindly come to serial number 1 at page 49.
Yes, my lord.
There seems to be some mistakes. What is this grade pay 2010?
Yes, my lord, that Lordship
So
will find.
here
No,
grade pay is of so and so. So initially he will get 14,000 plus 7,400.
Yes, absolutely.
First day appointment. Then after that they will increase.
And that Lordship is, that is.
And what is this? The next one is 14,650.
Yeah,
How it is? How does it become 14,650?
that will, my lord, then we define that under the scheme, my lord, under the ROP rules. That will be applicable to some other cadre, other posts. The post, Lordship will kindly mark the distinction here, my lord, here the post, which post, what category post, that is not spelled out here. What is spelled out here, my lord, this is a table. This is a table, my lord, 6.8.10. Now, this table speaks of the, my lord, the grade pay and parallel increase with regard to their, my lord, grade pay and the pay band. Therefore, at serial number 1, Lordship will kindly see, Lordship will kindly for the time being, my lord, skip the second column. Lordship will take the third column and the fourth column. Now, in the fourth column, Lordship will find of which pay band. Now, fourth column is the pay band. That is 14,000.
No, it's 14,000. It starts from 14,000 to 49,640. This is
Yes.
the payment.
Pay band. This is the pay band, my lord, from end to end, from end to end.
End to end. So it will be from 14,000 to 49,000.
Yes.
So
Yes.
that increase happens how?
Increase happens, my lord, it is a periodical increase, my lord. It is a
So
periodical
it is on the basis of the work being done.
increase.
So,
My lord,
so a person who has 14,000 after 3 or 6 months will get 14,650.
absolutely. Therefore, Lordship will kindly take the last column. And I am taking the first serial number 1. Lordship will kindly see the last column, it is 14,000. And just above 14,000, Lordship will find 7,400. So 14,000 plus 7,400 is total pay Lordship will find in the third column. Total pay is 21,400. Similarly, my lord, if we take serial number 2, it is 14,650 plus 7,400. If we add it, it comes to 22,050 rupees. So in this way, my lord, it increases. And this pertains to defined category of post. And therefore, what assumes importance here is, my lord, the advertisement. My lord, page
That's fine.
29.
To be clear on this. These payment increase is based on, means it is fixed,
It is fixed.
means how it is increased.
It is periodically, then my lord, it is related to various factors. Cost of living, then recommendations, periodical recommendations of the pay commission, then my lord, annual increase. All these things are there, my lord. Because
Now he has been given as per 20,590,
yes,
49 page. And therefore he is claiming 27,990.
yes, he may claim so, my lord. He may claim so.
But
20.
it cannot be 20,590. It has to start from 14,000.
Yes, it starts from, and therefore, my lord, also will kindly for a moment take up page 29. I am traveling, my lord, it on this page, my lord.
Okay.
Page 29, that is the advertisement. Kindly see the advertisement.
5,200.
Yes, yes,
Great pay of 2,000.
Yes, yes.
So this was increased to 14,000 to 4,000,
Yes.
49,000.
yes. Now, the stenographer grade 3, lordship will kindly see, my lord, vacancies of stenographer grade 3 for subordinate in the scale of pay 5,200 to 20,200 plus CP grade pay of 2,900 in payment number 2. Payment 2.
Now this is payment 2.
Yes,
Alexa 13 is payment 2.
yes.
So here it starts from 14,000 to 49,640.
Yes. And lordship, you will further kindly come to my lord, page 51. 51. Now, having noticed the anomaly, having noticed the error committed, this order has been passed. In view of Honorable High Court's letter dated so and so, the pay in respect of Azizul Haq Chaudhary now working at, this is with regard to my lord, another person, my lord. Azizul Haq Chaudhary, now working in the court of edition and so, and Ms. Dhoitri Deka, this, my lord, this is the petitioner. Now working in so and so in the Eastern Anove are refixed as follows with effect from 22/9/2016. Basic pay rupees 20,590 plus
22/9/2016 is the date of appointment.
yes, date of appointment. And why this anomaly has happened? Because my lord, the date of effect of ROP 2017 is my lord 1/4/2016. Now this advertisement was issued prior to 1/4/2016. This advertisement at page 29, it is dated my lord 12/6/2015. And her appointment, she came to be appointed, my lord.
On 22/9.
No, my lord, on 30 July 2016.
Where?
So
Where is it?
that page 33.
Eh?
Page 33. I was appointed at Nalbari initially.
No. This is not the appointment order.
Oh, this is the selection.
No. Her appointment is 22/9. Here, kindly see, page 39. This is the appointment. Our High
Yes.
Court has a different way. They give a place of posting without giving an appointment. That is another thing.
Therefore, my lord, prior to appointment, my lord, the selection. Selection is dated, my lord, 30 July 2016. So 15, and in the meantime, my lord, 1/4/2016, ROP came into effect. Thereafter, my lord, July 2016, she came to be selected. And finally, my lord, in August 2016, she came to be appointed. So therefore, my lord,
He was appointed on 21/9,
22.
page 39.
Yes.
This is the order of
Yes,
appointment.
yes. This is the order of appointment. 21/9. So 21/9.
She is appointed in the scale of pay of 5,200 to 20,200 plus GP of 2,900 and other allowances.
2,900, that is my lord pre-refined.
So now with revision, it will affect from this.
1/4/2016. And since my lord, in the meantime, she had already drawn, my lord, the scale which was erroneously of course given to her. Therefore, my lord, this clarification was sought by the learned district judge, which was duly replied to by the finance department at page 66. Page 66, and thereafter, my lord, page 68. This is the interim decision, page 68. Page 68. Yes, this is the, my lord, interim decision, my lord, whereby an amount of rupees 1,68,644 is now sought to be recovered, my lord. Excess amount refundable, shall be refunded in equal monthly installment of rupees 5,000, only from the pay bill of September 2022. This is the issue, my lord. Nothing complicated.
What is the Guwahati High Court stand?
There- there finally- it's neither here nor there. Like, they say that since the finance, there was no clarification after the finance department made their communication. So they stopped there.
Why? Guwahati High Court stand is what?
Lordship, they have filed an affidavit, Lordship, at paragraph 6. They have said that they preferred the communication before the finance department, and there
No,
were
no, Mr. Sharma, kindly say. Tell me, how do you come in number 10?
Lordship, page 45, Lordship, may kindly tell me.
Page 45. Yes.
I am reading from the
This is your letter.
this was a joint letter preferred by similarly placed incumbents, Lordship. Therein the calculation is put up, Lordship, before the register of this portal. From the bottom, that paragraph B, Lordship, we find out.
This is on a different thing.
That was
that calculation of 7,170 plus 290, that was in the pre-revised scale lordship. That was what was received by them. Now, that figure did not come up in the ROP rules 2017. And
This is on a different aspect. This is on equal pay. This is on equal pay with the stenographers in sub-secretary. This is on a different aspect. There is a calculation error. This should have been, in fact, it should have been under in the pay in the year of 7,100 to 20, the 7,100 it should have been, not 5,200. These are different aspects. But your advertisement was clear, 5,200. So the corresponding 5,200 would have been, it has to be 14,000. If it is 14,000, then it is, how do you jump to number 10?
the whole of that table lordship, in fact, relates to that pay scale itself lordship.
Understood. Therefore, my specific questions to him were, how does it increase from 14,000 to 14,650? See the, kindly come to page 49. First is 14,000. Second is 14,650. Get it? Third is 15,320. Fourth is 16,010. So this, now you come to 20,590. You are claiming I'm not number 10. Isn't it? How do you jump to 10? When your pay has to be fixed at the initial as per the actual 14,000.
Lordship, because when they receive their earlier scale lordship pay, when they receive their earlier pay lordship, as per their pre-revised scale lordship, they used to receive at the rate of 10,000.
No, you were a direct appointee only after that. I'm not concerned with others. You were appointed on 21/9/2016. After 1/4/2016. So the question 5,200 to 20,200 is the corresponding PB2 is of 14,000 to 49,000. So there is a increase of from 14,000 to 14,650, 14,650 to 15,200, and corresponding number 10 would be 20,590. Now these 20,500 plus the great pay gives 27,000. Now they have put you in debt. Why? That is the
Because my
answer.
appointment was in 2016, that's their scale lordship.
Huh?
Because my initial appointment was in 2016 lordship, that's why lordship. But then, if lordship perusers case 48 lordship, then this communication specifically relates to the stenographer's grade 3, which of the year 2016 lordship. And
No, Mr.
Yes, sir.
High Court may do many things. But the High Court is not the airport. The High Court may very well say that the person who is engaged as stenographer grade 3 in this post subsequently is the same equal pay. For that equal pay should be given to the person who were now in the pre-existing 2017 ROP. So they are getting more, so these people should get more. That is on a different concept as regards equal pay to equal work, which we are not concerned. We are concerned that when you were appointed,
lordship, that's what is their lordship, at lordship, this figure lordship, this was recognized lordship. 10,380 lordship, that was the pay that was recognized by this High Court lordship. So that's
the pay I ought to receive at the time of initial appointment. That's the pay I ought to receive at the time of initial appointment. Which one? Pre-revised scale, at pre-revised scale, Lordship. This, 10,380, Lordship.
You got an advance increment of 3%.
Yes, Lordship.
Why? Why was this advance increment given? By
Lordship.
some letter of the government.
Yes, Lordship. There are communication dated 13/6/2019. I don't know what's there in that communication, but it was fixed, Lordship, that 10,380 at the pre.
What is this basis of advance increment?
Advance increment, it is done, my lord, to prevent stagnation, my lord.
This is of a MACP.
Not precisely MSCP, my lord, if a person is, my lord, appointed, my lord, at a point of time when, my lord, a person who would have been appointed, my lord, let us take a situation, my lord, I am eligible to be appointed today. Somehow I am not appointed, not because of my fault. I am appointed at a later stage. And in that later stage, my lord, the similarly situated persons, they get a increment, my lord, of, say it is 3% or 1%. Then to compensate that, my lord, this advance increment is given. And here the issue is absolutely clear. The advertisement, my lord, the first appointment order, then, my lord, the table which has been relied by the petitioner, everything goes to show, my lord, that the payment it is that pay scale. It is that payment, my lord. It is that great pay. So here, my lord, he is a fresh equity.
So you therefore say that he is not entitled to the advance increment.
Under no circumstances. And that has been clarified, my lord, by at page 66 by the finance department. Only because of the fact that, my lord, some error took place in, my lord, releasing the pay, and later on it was found, my lord. And this petitioner, my lord, along with that other person, took up all kind of plea and, my lord, confused the authorities. Therefore, my lord, under that circumstances, the learned district judge has sought that letter to the finance department, which has been duly replied to, my lord, explaining the entire situation that much. And in doing so, my lord, it is expressly, my lord, evident on the face of the record, my lord, that he received this amount, my lord, so altogether 1,68,644. Now, only to escape from this liability, my lord, perhaps this petition has been filed, my lord, with taking all sorts of, my lord, plea. But, no.
They have not denied that I am not entitled to this pre-revised scale of pay, Lordship. That appears at page 48, Lordship.
No, you are entitled to your appointment letter, which was given on 22/6, 22/9, 21/9. Categorically says that your scale of pay would be 5,200 to 20,200, which the rate pay of 2,900.
But at which stage they will fix it, Lordship, that's not been verified anyway, Lordship.
No. Thereupon, your corresponding scale of pay at the time of appointment should have been on the basis of 14,000.
But
Unless you give me a satisfactory answer, as to how can you jump to number 10?
that's what page 48 says, Lordship.
Page 48, these people may do many things. I'm not on that. But the question is, you have to give me a satisfactory answer as to how do you jump to number 10? They may write many things. The Bombay High Court is very kind to its employees, but that does not make that these employees will be the government has to pay.
Then this has to go, Lordship. If this does not go, Lordship, then Lordship, I will be discriminated, Lordship.
Why?
Because others are receiving, Lordship.
Others are receiving means anybody who is appointed
Relates to
along
all the
with you.
stenographers creating, Lordship.
Now, who is appointed along with you?
Yes,
If they are getting and there is no thing being done, can we apply a negative equality?
yes. I am claiming on the basis of this letter, Lordship.
No. These letters can have no business. You see, these posts are being sanctioned. Everything is being sanctioned by the government. These amounts are to be paid as administrative expenses.
Lordship, apparently, Chetty Commission came into being because of this anomaly, Lordship. It was stated there in that, Lordship, the appointments under this institution has to be granted higher pay scale, Lordship. And to protect them.
That is another question. Has to be granted more than that is a different thing, but that is not your question. Yeah,
That was.
you
taken
are
into
coming and
consideration.
jumping to, you are still saying that you are entitled to number 10. What is your basis to 10? Why are you claiming on number 10?
Because Lordship, the initial pay at the pre-revised scale was fixed as per this communication only, Lordship. That is at page 48, Lordship.
Page 48 happened in 2019. This happened in 2019. You got your salary on 21/9/2016. You must have got your salary the next month.
Yes, I received, Lordship, but
Then
at that point of time, they give me, Lordship, that pay scale.
let them give it. Let the
Subsequently-
Guwahati High Court. Okay, the Guwahati High Court does not want to do it. Very well. Let the Guwahati High Court pay it, but give it to the government back.
But-
Guwahati High Court may be very generous to you or gracious to
No,
you.
once
Let
they
the
paid,
High Court
Lordship,
pay it from its own
had I
pocket.
not received it, I would not have questioned, Lordship, and they paid it, Lordship. Subsequently,
The question does not arise. It is after all government money.
But I could understand whether it is projecting a case of negative equality. It's not permissible.
No, not permissible this time.
Not permissible. That's a settled position of law.
on the basis of this only, the fixation was made, Lordship. My
So,
case, there was only.
Rely
Let them get that, Lordship. They have not said anything with regard to that. Even in that communication also, Lordship, which he is relying, Lordship. They did not say that page 48, which the order was passed, that has been counted, Lordship. That has not taken.
It
that
is
has
not
not been-
communicated to us. Why should I? Why
But
should I?
initial fixation, the advertisement was made by the High Court, Lordship. It
So
was-
this is, how can you say that this has any relevance with your initial fixation? This is a document of 2019.
Because, Lordship, the subject, Lordship, in Kandi Perusi relates to that one only, Lordship. Subject in that page 48 subject.
Mr. Counsel, this was done in 2019. You say that you forego all your salary from 2016 to 19. Very well. We will consider this. This was done subsequently.
The anomaly was there, Lordship, existing in that,
And then be
because the others received, there were around 199 appointments, Lordship, at that point of time, 191. And all of them are receiving the pay scale, Lordship. And how can they, Lordship?
where have you mentioned others have got it? Show me in your petition?
Paragraph 10,
Paragraph?
10, Lordship.
Yes.
Ten and 11.
Where?
Paragraph 11 is the same determinant on which
Then-
reliance has been placed.
That initial,
You are saying that you, along with other three who were appointed, were given less salary.
yes, Lord.
You got more. You have to pay it back.
Others are receiving otherwise, Lordship. Around 191 appointments were made at that point of time.
You make out a case of whatever may be. City Commission is a recommendation.
Lordship.
No.
That was acted upon in the pre-device scale, Lordship. They gave it to me, Lordship, in that pay scale, Lordship. And in the Lordship will kindly,
Show me the City Commission's report. Where does it say that you have to give more than what is given in the ROP?
I have a soft copy, Lordship, but then.
Does it say so?
Yes, Lord.
That it has to be given more than what is given in the City Commission ROP?
Yes, Lord. That was specifically for the,
Where is your representation to that effect? That you have to be given more than that?
no, but I,
No. Tell me, where is your representation? You have never represented before any authority that you have to give in as per the City Commission's thing. And for that,
because my initial.
no,
they
for that, the state, the High Court or the High Court has to make a certain recommendation to the state. And the
That-
state
that
will,
was done, yeah, the state
the state
commission
will have to
came
do
in
it.
At the time of pay commission, Lordship. And therein the pay was recognized, and this is the amount which was the, which was fixed in the pay pre-device scale, Lordship, 10,380, which is 7170 plus grade.
No case, no case,
900, Lordship.
no case. You are not charging interest? Interest. Interest from them for retaining this money for such a long time.
No, my lord, we have rather given them higher leeway, my lord, that you deposit in equal installments of rupees 5,000. That lordship will find that page 68.
No, but he's saying that the amount has been, they are not deducting now. So let the,
That is
where's the High Court counsel gone? You do one thing, Mr. Babujai,
my lord.
we will take up this matter again on 20. Today is 17, na? We'll take it up on 27. If you file your reply, you file your reply. If you don't, okay. That is your lookout. But if you file, you pay 7,500 as cost for receiving, 10,000, 7,500 shillings. 10,000. It is seen that the finance department have taken time on 27/1/2025 as well as on 14/2/2025 for filing the affidavit. However, no affidavit has been filed. This court, by the order dated 14/2/2025, have observed that a final opportunity is being granted. In spite of that, the finance department of the government of Assam have not cared to file the affidavit. Today, Mr. R. Babujari, the learned standing counsel for the finance department, submitted that further time is required for submission of the affidavit. And in that regard, have placed before this court an instruction dated 13/3/2025. It is the opinion of this court that on the earlier occasion, time was sought for on the ground of the ongoing budget. And this time, the time has been sought for ongoing of the 15th Assam Legislative Assembly. On the ground that there is a budget session going on, this court had granted an adjournment on 14/2/2025. However, that does not mean that the finance department can take advantage of the Assam take advantage that the Assam take advantage that the Legislative Assembly is in session and not file the affidavit. Considering the above, this court fixes this matter on 27th of March 2025. A final opportunity is being granted for the ends of justice to the finance department to file the affidavit, subject to depositing a cost of rupees 10,000 before the registry of this court. It is observed that if no affidavit is filed, this court shall proceed with the disposal of the petition on the basis of the materials available on record.
With that figure of 10,000 something lordship, that figure of that amount in the pre-revised scale lordship, which appears in that letter at page 48 lordship, in the affidavit filed by the Guwahati High Court lordship, at paragraph 2.
Yeah, Guwahati High Court's affidavit does not make head or tail of what they want to say.
No, that
I've read it thrice and thrice I have not been able to understand.
in the paragraph 4 lordship, that
Paragraph 4 is there. They mention about that letter. I understand, but I don't understand what is the logic. The issue is very simple. Issue is the advertisement stated 5,200 and 2,000, 20,000, 200 with a great pay of 2,900. On the basis of the advertisement, you were appointed, given an appointment letter with that payment and the great pay. The correct the revised payment and grade pay in respect to these after the ROP comes is 14,000 to 49,000 plus grade pay of 7,400. However, you have been shown at the fitment table number 10, whereby you are to get 20,250 plus grade pay of 7,500, 400, which makes it 27,790. How? That's the issue. You bring city commission, all these things are not the issue. This is the point.
Item 16, hearing under order 41 rule 26.
Then that is the line লিখে দিবে। In the circumstance, the amount of rupees 10,000 is deposited while filing the affidavit. The registry shall place the affidavit then disburse the said amount to the legal service authority.
I'm obliged.
Yes, because of you, legal services authority will get 10,000, nothing more.
I'm obliged.
Yes, what is this?
I got did item 16, madam. 16. Kind of pass over the matter for the timing matter.
16.
16.
Is there any urgency?
No, there is no urgency.
Don't be urgent.
Hello.
This is a very bad code for order 41 rule 11.
Yes.
So better off wait for the next turn. Mr. B. Kaushik has come.
Sorry.
Wait for the next court or take it before any other court. There is another court, senior court out there. Take it there. You may have some good opportunity.
Fine.
For me, this is a case for dismissal. Isn't it? It has not yet been admitted by these courts. That means 100% is a case of dismissal. Leave the matter on 2nd April 2025 at the request of the learning council for the applicant.
Okay.
Okay.
For orders, item 17. Item 17,
Yo Kanil. The call is it, service is
item 17 for orders.
none appeared on behalf of the appellant on call. It is further seen that the appellant had not been represented on 8/1/2025 as well as on 2/12/2024. It appears that the appellant must have lost interest in the instant proceedings for which the appeal stands dismissed for non-prosecution. The registry shall return the courts below. The courts to the court. What are these? What matter?
That matter, madam, where the opponent has expired. Mr. C. Goswami had that.
So we do one thing, we substitute it and dismiss your appeal. You don't have a case. Didn't I hear that? Of Mr. Kane should be arguing that way.
Yes.
You escaped on that day the dismissal saying that the appellant had died. Don't pass an order against the dead person.
Ballard was saying that we had a good case. That day.
Did I say that? Yes. I never said that it was a case. Who died?
Ballard the appeal.
Yes, Mr. Counsel. Didn't I say his appeal was meritless?
Died, my lord. I also got information he died, my lord.
Understood. Didn't I say that the appeal, there is no case? I wanted to dismiss the appeal.
Yes,
Last
wanted to,
appeal.
yes, sir.
In the first half. And the second half, he said that the appellant died. Didn't it?
That case, my lord.
Huh?
That case.
Remember,
On cross-examination part also, my lord, your chief read.
notice. So what is this? How many days?
IA 627 is it?
No, that sooner is better. Sooner is better, my lord, for me.
You are paying for the other side, no?
Yes.
Mr. Aid, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears on behalf of the respondent. The three applications herein are applications. By this common order, this court proposes to dispose of the three applications so filed. ISC number 627/2005 is an application seeking condonation of delay of 216 days in preparing the application under Order 22, Rule 3. Seeking substitution of the appellant as well as the application under Order 22, Rule 9 for setting aside the abatement. IA 621 is an application filed under Order 22, Rule 9(2) for setting aside the abatement. And IAC 628/2025 is an application under Order 22, Rule 9, Rule 3 for substitution of the appellant. How many appellants?
Three.
All three died.
No, my lord, appellant, one second.
Appellant was one.
Yes,
The appellant.
substituted by the.
Mr. So-and-so, the learned counsel appearing on behalf of the appellant, a respondent, admits that he has no objection. Considering the above, the delay in filing the application seeking setting aside of the abatement is condoned. Accordingly, IA 627/2025 is allowed. Further to that, taking into account that the counsel appearing on behalf of the respondent further does not oppose the application filed under Order 22, Rule 9. The application being IAC 621/2025 is also allowed. Thereby, the applicant, thereby, the abatements insofar as abatement of the instant appeal insofar as the respondent number appellant is concerned is set aside. It is further seen that the appellant herein is appellant of the suit and the appeal is survived by the applicant numbers 1 to 4. Taking into account that the right to sue continues, pursue the appeal continues after the death of the appellant. The respondent here, the applicants herein, applicants in IAC 628/2025 are substituted against the appellant number, against the sole appellant. The counsel appearing on behalf of the appellant is directed to file an amended memo of parties before the registry of this court within 3 days. And on the basis of which, on the basis of the instant order as well as the memo of parties so filed, the registry shall make necessary correction in the memo of appeal, as well as also update the same in the CIS. Silicon disclosed. So, taking into account that the appeal is otherwise ready for hearing and the matter was heard. On 31/2025 by this court substantive. This court fixes this matter on 25th of March 2025 for final disposal at the top of the list.
Okay. 19.
Their service complete, record that also.
You are appearing? You have filed a fresh Mukalatnama. And what remains?
Service complete today.
Service complete, LCR received, no? LCR received?
Yes, sir.
Received. This is the matter for hearing in the usual course, liberty given to both the parties. It's a matter for hearing on 3rd of September, 3rd of April 2025. Full stop. Taking into account that the instant decree is of the year 2024.
20.
Filed to the 2016. What is the CRP of 2016 doing here?
Respondent number 2 and
No, forget about respondent. What is this type of matter?
better lordship, the claim.
What are you
was returned-
challenging here?
Claim petitioner was returned to the claimant on
Huh?
ground of lack of territorial jurisdiction.
Which one? None appeared.
Will you kindly see the 45 plus 2 paragraph?
What is wrong?
Township tax remains that insurance company is having its office within the jurisdiction of insurance company had is having.
No,
its
you were asked to go and find it somewhere else. Why haven't you find it? First of all, you don't appear. For 3 years, you have not appeared. Then nothing of this. This is a case rightly passed. Therefore,
Claim petition was
no, nothing.
dismissed on the
Supreme
ground
Court,
of lack of territorial
Supreme Court may help you, not me. These type of matters should not remain. You see, injury, it's a case of injury of 2013. You don't appear for 3 years before the court. You don't file anything, no evidence, nothing. Then the court looks into it and finds out that then also the court was more considerate. I should have, if I was the judge, I would have thrown out. But he was very considerate even to give you a chance to go there. But you have not gone there. And you are coming out
direction.
here.
That direction will be given.
What? It is already
That-
there. It's already there. Considering the above claim is returned to the claimant after observing all formalities with the direction, the case is closed. Then the court exercised Order 7 Rule 10.
Direction will be given to approach the appropriate. To approach the appropriate.
What? You withdraw this.
In the
Heard Mr. M. Talukdar, the learned counsel appearing on behalf of the party, and Ms. M. Chaudhary appears on behalf of the
Number 4, Oriental Insurance Company.
Oriental Insurance Company Limited. The instant proceedings have been filed challenging an order dated 28/6/2016 passed by the member Motor Accidents Claims Tribunal, Silchar, Kachar. So this court have perused the order dated the impugned order. And from a perusal of the impugned order, it is seen that the claimant had not taken steps in the said claim proceedings. Apart from that, it is also seen that the learned tribunal further took note of that the claimant is a permanent resident of Karimganj district the owner of the vehicle is a resident of is not a resident of Kachar district, and the accident took place in the state of Meghalaya. Considering the above, the learned tribunal had come to an opinion that the tribunal did not have the jurisdiction to entertain the said case. It is under such circumstances that the claim proceedings were returned. This court, having perused the said order, does not find any ground to interfere either under its revisional jurisdiction under Article 115 of the Code or under the supervisory jurisdiction of this court under Article 227 of the Constitution. Accordingly, the instant petition stands dismissed. Be that as it may, taking into account that by the impugned order dated 28/6/2016, the learned tribunal had only returned the case, returned the claim petition. The counsel, the claimant would be at liberty to file the said claim proceedings before any other court, before the tribunal having the jurisdiction. In that regard, the period from the date of filing of the instant petition, that is 27/9/2016 till date be excluded.
Tribunal at Silchar has the jurisdiction. Has the jurisdiction, Lordship?
No.
Because the office of the insurance company is at Silchar. Similar judgment is present.
Okay. তেতিয়াহলে এইখিনি লিখি দিলো। I have returned the petition, I have returned the file, that have returned the file of death. This court have taken the manner in which the claimant have proceeded in the same claim proceedings. It is the opinion of this court that the learned tribunal ought to have dismissed the said proceedings, taking into account that the claimant was not interested. Considering the above, this court finds no ground to interfere with the impugned order. Accordingly, the petition stands dismissed. This goes for entirely. Earlier, there was some opportunity, now nothing.
Okay.
12/3/25, steps for R7 and R8 are not yet complete, Your Lordship.
Which 7 and 8?
Owner and driver of the vehicle.
What is your contest? What are you challenging on?
The main ground is quantum, Your Lordship, that the income certificate was not proved.
That's it.
Your Lordship, if Your Lordship may permit, we can dispense with the service upon R7 and R8 because our ground is only in quantum.
So what was not proved?
The income certificate, Your Lordship. It was executed, but it was not proved.
you give any evidence? Hmm? Did you give any evidence? Sir, what do you mean? Court reduced it from 14,000 to 8,400. What is that?
So Lordship, the notional income around this time was 6,500.
Huh?
Around that time, the notional income was 6,500. As per the judgment reported in AIR 2000.
Oh, yeah, he has given that certificate of the Jayantya Hills Autonomous District Council, given by the member district council to the effect that he used to earn 1,70,000 per month, per year. What is that? How much he has got?
10 lakhs, Your Lordship. We've already paid 10 lakhs.
12 lakhs.
The total amount was 12 lakh 36,000.
Hmm?
12 lakh 39,600 was the total amount, and we have already paid 10 lakhs.
Very well. Pay the remaining. I dismiss. Administration of the Learned Council appearing on behalf of the appellant, none appears on behalf of the respondent or party. With an appeal filed under section 173 of the Motor Vehicles Act 1980, challenging the judgment and award dated. Judgment and award dated 10th of October 2012, by which the learned tribunal, learned member, Motor Accidents Claims Tribunal, Kachar, Silchar, hereinafter referred to as the learned tribunal, had awarded an amount of rupees 12,39,600, along with interest at the rate of 9%, with effect from 27/7/2009 till realization. Firstly, the learned counsel appearing on behalf of the appellant had submitted that the only ground of objection taken to the state impugned judgment and award is that the certificate, the income certificate was not proved. Firstly, this court have duly taken, firstly, taking into account the said ground of objection, let this court take up the instant appeal for final disposal. Firstly, the case in the present case, the materials of report shows that on 3/11/2008 at around 5:30 AM, the one Hamdev Lamare, HAMDIAW, Lamare, the Lamare, while boarding on the Bazaar bus bearing registration number ML048067, was proceeding from Infructuous to July. At around 8 AM at NNGRYNGHGKOA village, the bus fell into a deep gorge, resulting in accident causing fatal injury on the person on Hamdev Lamare. And accordingly, he succumbed to his injury and died on the spot. Pursuant to that, a postmortem was conducted. Pursuant thereto, investigation and FIR was filed, which led to the registration of FIR was filed on 4/11/2015. FIR was filed. FIR was filed on 3/11/2008, which was registered as Varampani, na?
Yes, Lord.
OP case number 34.
The Lordship FIR was filed on 4/11,
4/11,
2008.
4/11/2008, which was registered as Garampani UP case number 34. Proceed. It is also seen that there was an order passed by the Deputy Commissioner, Joint Hills Autonomous District, which have been exhibited as Exhibit 5, wherein it has been stated that Hamdi Lamare death was caused due to an accident by the bus ML048067 at Nongring village. And it was opined on the basis of the report from the officer in charge of Garampani Police Outpost that the cause of death was purely an accident and there is no suspicion of any foul play in the accident. On the basis of on account of the death of the late Hamdev Lamare, the claimants filed the claim proceedings, which have been registered as MAC case number 972 of 2009 before the learned tribunal. None appeared on behalf of the owner as well as the insurer, or owner as well as the driver. However, the appellant insurance company appeared and filed a written statement. On the basis of the pleadings, the learned tribunal framed three issues, which were: number one, whether the application for claim is maintainable in the present form. Number two, whether the claimant is entitled to compensation as paid for. And number three, to what relief the parties are entitled to. On behalf of the claimants, the wife of the deceased filed her evidence on affidavit and had exhibited various documents. The various documents are the accident information report, the certified copy of the FIR, certified copy of the inquest report of the dead body of the deceased, late Hamdev Hamre, semicolon, the certified copy of the dead body challan of the deceased, semicolon, certified copy of the postmortem exemption report of late Hamdev Hamre, Lamare, issued by the Deputy Commissioner, Jayantia Hills District, Jowai, as well as the income certificate of Hamdev Hamre issued by the member District Council, Jayantia Hills Autonomous District, wherein it was mentioned that the annual income of the deceased was from his occupation as a coal field contractor was rupees 1,70,000. The said witness was cross-examined by the appellant insurance company. The appellant insurance company, however, did not file any evidence. The learned tribunal, by the impugn judgment on order date, award dated 10/12/2012, awarded an amount of rupees 12,39,600, along with interest at a rate of 9% per annum with effect from 27/7/2009 till realization. It is relevant to take note of that although the Exhibit 6 categorically mentioned that the annual income of the deceased was 1,70,000 per annum, which commensurates to rupees 14,000 per mansum. The learned tribunal only granted 8,400 per month, taking into account that the business of coal was not stable at all time. This court further perused, further have also perused the compensation which was awarded by the learned trial court, by the learned tribunal, and the manner in which the computation was carried out. This court finds no ground to interfere with the impugned award, and accordingly, the instant appeal stands dismissed, the Ms. So-and-so, the learned counsel appearing on behalf of the appellant submitted that an amount of rupees 10 lakh was deposited before the registry of this court at the time of admission of the appeal. The remaining, appellant insurance company is directed to deposit the remaining amount along with interest before the registry of this court within 6 weeks from the date of the instant from today. And on the basis thereof, the registry shall thereupon release the said amount on application being filed by the claimant after making proper verification, identification, and on furnishing of the bank details. Appeal stands dismissed. Good appeal is dismissed because otherwise the amount would have gone higher.
And in this case, your lordship was directed us to ascertain the address of respondent number 3 and 4 matter. But according to the information of my client, my lord, the respondent number 3 address was collected from her certificate of registration of the vehicle. Address of the respondent 3 was collected from the certificate of registration of the vehicle. And the respondent address of respondent number 4 matter, new address which was the collected. So I may be permitted to take step by separate advertisement.
Your appeal was dismissed.
Yes, ma'am.
Why?
Madam, for non-appearance of the advocate, you put a limit put to the respondent 3 also appeared. You put a limit trial put to the
You have not deduced evidence also. What can I do here?
you be remanded now.
Why? In a case which is of 2010, 15 years have gone by. What is there to remand? You don't give evidence. How many times? Some record is in it. The judge who had taken up the matter has now become a judge of the High Court in retired also. But your matter has not finished.
It's 8, 6, 7.
Could not appeal. 3 months. 28, 2017 to 23, 6, 2017.
How many times last chance was given? One
the
chance,
earlier
two
occasion,
chance,
we have
three chance is last chance.
Well, on the earlier occasion, we have taken step, but there was settlement. Step was taken.
Forget about steps.
But full logic.
I can't pass an order in your favor in absence of the other side. But I can very well dismiss your case without them. Why should we interfere? You were given ample chance to reduce evidence. You did not reduce evidence for 6 occasions.
8, 370 to 23, 670. 4 days, 4 times.
4 times.
So,
10/6/2016, first time. The
Eviction.
29, 22/9/2016 for evidence of the claimant. First,
Yes,
you did not do anything. You took time. So the next date is fixed on 8/11/2016. 8/11/16, you did not do anything. Again, the matter is fixed on 12/12/2016. 12/12/2016, I don't know what happened, but anyway, from 22/2/17, again, you took time.
yes.
And the court gave you a last chance, the first last chance. Then fixing 28/3/2017, 28/3/2017, the second last chance. The
Few days.
second time.
Yes,
last
yes.
chance. Then on 25/4/2017, the third last chance. Then on 28/4/2017, the fourth last chance. How many last chances is there? Tell me.
On that occasion, my lord, the learned advocate for the claimant did not appear.
No, please. No, there has to be an end to all these recommendations. Can't help it. If you are not concerned with this, one has to be. It's sad, but you can't help it. Yeah. What is this? Well, so, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, appellant, and Ms. So-and-so appears on behalf of the appellant insurance, respondent insurance company. The present appeal has been filed challenging the judge order dated 23/6/2017, by which the learned member, Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati, had dismissed the claim proceedings, being MSC case number 885 of 2011. The ground of objection so taken in the instant appeal is that the appellant was not afforded adequate opportunity to this court have perused the records as well as the impugned judgment and award, and have heard the learned counsels appearing on behalf of the parties. It is seen from the records that pursuant to filing of the claim proceedings, the owner of the vehicle as well as the insurance company have filed their written statements. On the basis of that, two issues were framed, which pertains to, number one, whether the vehicle victim Durlabh Soikia died in the alleged road traffic accident on 31/12/2010 at Panighati due to rash and negligent driving of the vehicle, driver of the vehicle number AS01Q3045 mini truck Kochumba. And number two, whether the claimant is entitled for compensation, if so, from whom, and what will be the just and fair compensation. First, it is seen that the said claim proceedings was filed in the year 2011. In the said claim proceedings, the claimant did not file any document which would show that the claimant that there was a vehicular accident which took place on 3/12/2010 at 4:10 p.m. at Panighati, Lohapara, wherein the husband of the claimant died in the motor vehicle accident. Son of the claimant had died. In addition to that, the claimant further failed to prove by introducing any evidence and rather preferred not to appear before the tribunal to proceed with the case. This court, upon perusal of the records, upon perusal of the records, finds it relevant to observe that the learned tribunal, after framing of the issues on 10/6/2016, fixed 22/9/2016 for the purpose of evidence of the claimant. The claimant took time on 22/9/2016, 8/11/2016, and 22/2/2017. And the court thereupon, on 22/9/2017, made it categorically clear that the next date was fixed on 28/3/2017 as a last chance. However, on 28/3/2017, 25/4/2017, as well as on 28/4/2017, the claimant did not adduce evidence in spite of opportunity being provided. It is seen that thereupon, on 23/6/2017, the learned trial court, the tribunal, taking into account that there was no evidence adduced by the claimant, had dismissed the said application and dismissed the claim proceedings. This court had also seen the reasoning assigned by the learned tribunal. And from the said reasoning, this court finds no ground to interfere with the said order passed in or the judgment dated impugned judgment dated 23/6/2017 passed in MSC case number 885/2011. Accordingly, the appeal stands dismissed. The registry shall return the reports.
Twenty-four.
Yes, what is this? What are you challenging? PPC. Yeah. Section 10. Yes, tell me. Section 10 was dismissed.
Expressing that we were
as a plaintiff, we have filed a suit in Guwahati. They have filed a suit against the same agreement in Kokrajhar. The suit in Guwahati speaks for evidence on next month. So we filed a section 10 petition in Kokrajhar on the ground that the parties are out of the same agreement. Both parties have litigating, they are claiming some reliefs against the same agreement. For damages they have claimed against the same agreement, and we have claims non-performance. Some work orders were made to supply some blankets. So in order that we have filed a case in Guwahati.
So one is a title suit
Title suits.
filed by plaintiff.
Plaintiff, you are in Guwahati.
You are the plaintiff
Plaintiff,
in title suit
title suit.
seeking
Seeking some payments were not, performance was not given as per the agreement. Phase 50 well. It's a declaratory suit. Declaring saying that mobilization.
declaring that
once-
the defendant had breached the agreement dated so and so. Decree declaring the defendant has misrepresented before the plaintiff and defrauded. Decree declaring they have received mobilization. Decree declaring that the plaintiff number is entitled to the refund of the 65 lakh. Decree declaring the defendant is liable to return a sum of 55 lakh. So this is what you are asking. And what has happened? Who filed the other suit?
They have filed in Kokrajhar. It is the same agreement, but it's for money suit. Money suit
You are asking money.
For that, money may not, as per agreement, which already we have,
Is it in respect to the same agreement?
agreement was same, but cause of actions are different.
Cause of action is different, obviously, but the agreement is same.
Same, may not works.
Now, if what happens that is he asking that about the declaring the defendant has breached the term? Now, if the trial court comes to an opinion that there is a breach, then what happens?
May not, cause of action was arose in the district of Kokrajhar. Yes.
Maybe
Yes.
there's no quarrel with that. The Goel versus Nobel Goel.
I found one judgment matter on the same issue matter.
What are two others?
One judgment I have found on the same facts, man. For the law firm. In this case also, my lord, one party supplied some goods, my lord. Some money was not paid, therefore some of the goods, my lord, he not released, man. Thereafter, one suit was filed for releasing of goods and was another one filed for money suit, my lord. Paragraph number 5, my lord. Agreement same, yes.
Which suit has been filed previously?
previously our suit in Guwahati in 11/20, they have filed in December 20 in Kokrajhar.
Why don't we do one thing? Transfer this suit, money suit filed to Guwahati.
But the cause of action was arose in the Kokrajhar because yes,
Understood. Let it be in Guwahati. and both person can appear because this is the first suit.
There, my lord, but that is not their pleaded case, my lord.
Huh?
That is not their pleaded.
Where was the agreement?
Agreement was signed in the Guwahati for execution of work in the Koprasar.
Maybe, but the agreement was signed here. And where's the agreement?
Agreement page starts from, my lord, page number, Board of Resolution, page 20. Agreement 21.
Are you contesting the jurisdiction out here in this court? Of Guwahati court?
That is
In your written statement out here?
such my lord.
You
Perhaps
you filed a written statement.
Perhaps not, ma'am.
Find it out. If you are not, then why don't you have it here? Both of you can do
I'll
the
also
hearing
take
because
instruction, my
you
lord.
see,
that-
one is like a claim, the other is like a contempt.
Yes, yes, I understand.
So both can be decided together. The basic intention of section 10 is that there should not be any conflicting judgments. So let's one court decide.
I'll take it, on that point also, I'll take it, instruction from my client. As per the case to the law.
Take it. And then you can file an application. One of you can file an application here, then I'll exercise 24 and transfer it here. I think that is the best way of. Will help both the
Yes,
parties, unnecessarily fighting in two litigation. Because one party may give this amount, you may be entitled, but then the question again comes of set off. You may be entitled, he may get the relief out here. You see, his case is that you have breached.
Yes.
A breach, the only way is that he will be entitled to compensation. He cannot get anything else, he can get compensation. So he will, let us assume that the best case, he gets some money against you. On the other hand, you are also claiming some amount from him. So tomorrow at the time of execution, that will be a great problem.
The calculation part.
The set off and all these things. So if one court looks into it, one suit and the other as a counterclaim, you consolidate both and make it one.
I'll take this.
You also take it. When?
I'm ready.
Heard Mr. P. Kotoki, the learned counsel appearing on behalf of P. Kotoki. Learned counsel appearing on behalf of the petitioner and Mr. Alberto who appears on behalf of the respondent. The instant proceeding arises out of by way of the instant proceeding, an order dated 30/10/2021 by which money suit number 5/2000 30/10/2021 have been challenged, whereby the learned court of the civil judge Pokraja had rejected the application filed by the petitioner under section 10 for stay of type money suit number 5/2020 pending disposal of title suit number 377/2020. This court have perused the claims of both title suit number 377/2020, which have been filed before the court of the civil judge number 1 Kamrup at Guwahati, and as well as the plaint of the money suit number 5/2020 filed before the court of the civil judge Putraja. From a perusal of the said the averments made in the plaint, it transpired that while title suit number 377/2020 can be said to be a claim against the defendants herein, against the respondent herein, the money suit number 5/2020 appears to be like a counterclaim by the respondent against the petitioner herein. Considering the above, this court is of the opinion that the best, that taking into account the basic idea behind section 10 of the Code of Civil Procedure, which is to avoid conflicting judgments by the courts, by different courts exercising similar jurisdiction. It is the prima facie opinion of this court that the powers under section 151 can be exercised for the purpose of conciliation of both issues. In that regard, this court have inquired with the legal counsels appearing on behalf of the petitioner as to whether, on behalf of the parties, as to whether they would be inclined to file appropriate applications seeking transfer of one suit to the transfer of the suit, the later suit, to the suit to the place within which the previous suit has been filed. Mr. Abdul, the counsel appearing on behalf of the respondent submits that he will take instructions. This is the matter again on when? 28th of March.
26.
Yes, madam. Oh, they asked for time today. You are going for whom?
Then 1 to 6.
They're taking into account that the survey. None appears on behalf of the petitioner on call. However, the respondent, Ms. So-and-so appears on behalf of the respondent number 1 to 6. This court have also taken note of the office note dated 6/9/2024. And accordingly, the service upon respondent numbers 7, 9, 11, 12, 13, 14, 15, 16, and 19 is complete. List the matter of the 6 weeks.
Twenty-seven.
Yes, what is this? What is it challenging?
By Mr. Lordship, the conducting counsel is legs for another court option.
What?
The conducting
So
counsel is legs
challenging.
for another.
Service is complete. So this court have duly taken note of the service report, office note dated 26/9/2024. Which mentions that as per the report of the process server, the service upon the co-respondent have been duly effected. Taking into account the above, this is the matter for admission. With 4 weeks.
Twenty-nine.
Service being complete And records having been received, list the matter for hearing in its usual course, liberty given to both the parties to file application for early hearing. Order.
Thirty-one.
Full respondent is expired.
Where 31.
Item 31.
Who is appearing?
So that I was appearing when 31.
When did he die?
23/1/24.
When did you, when were you informed?
Yesterday I was very engaged.
Do you know the legal representatives?
I will get all of them provided.
Mr. So-and-so, the learned counsel appearing on behalf of the learned counsel submits that he was earlier engaged by the sole respondent in the instant proceedings. He submits that yesterday he was duly informed that on 23/1/2024, the sole respondent had expired. He further submits that within 7 days he will be providing Mr. S. Islam the details of the legal representatives, if any, of the sole respondent, to list the matter after 4 weeks.
32.
In the meantime, you take steps. 4 weeks means you take steps. Yes, 32.
32. Three of the respondents have expired. Three of the respondents have expired as published.
Who?
8 Roman 1, Roman 2, and Roman 3.
Huh?
8 Roman 1.
Yeah, performer. Why you are doing against performer? They can be sort of.
They have supported the case of the plaintiff by filing written statement.
Why you are making them a performer then?
Is present.
Why you are making them performer then? You gotta stay. You gotta stay. You vacate the stay. No, continue. Vacate for this should be. The delaying technique should not be there.
But if otherwise,
No, we vacate the stay.
Roman
Then
4,
things
5,
will
and
move.
6, they are the sons.
Okay.
They all they are.
We vacate this order. 7/8/2023. Then things will move.
Roman 4, 5, and 6. Lordship, they are-
Whether state of Assam is a necessary party in the suit as the suit land being annual patta and the paramount title of the land lies in the state of Assam, not necessary. Whether the prayer for cancellation or mutation in favor of the appellant is barred by time, this is obviously nothing. Whether prayer for partition of the annual patta is maintainable. Whether the jurisdiction of the civil court is barred to cancel mutation under section 154. No case made out. Let us dismiss the appeal. Okay, argue.
Lordship, otherwise 4, 5, and 6. Lordship, they are the.
No, forget
they are from
about that. Argue.
They are from the same family. Lordship.
Mr. Bhardwaj, argue the appeal.
Otherwise.
No, now. I can't pass order against dead persons. But in favor of the dead persons, they will give me some blessings. Now come,
They are two connected.
argue.
They are two connected.
You don't have, these are not substantial questions of law. Under no circumstances. State of Assam is the necessary party in an annual. What is the suit for?
It was for recovery position right title.
Then annual patta given. Then if an annual patta is given, it has a hereditary right. It may not have a hereditary right, but then also there are many judgments of the Supreme Court from our High Court rights from 1950 onwards, wherein it says that the person has the right, can also be transferred until the annual patta notice is not issued, his right continues.
For this.
What are you speaking out here? Because I have too much time today. So let us dismiss one second.
4, 5, and 6, they are from the same family.
A decree be paid directly declaring the plaintiff has right title and interest and confirmation of possession of Schedule B land of the plaintiff as a legal heir of Bahir Ali. Then annual patta land, where is required? The decree be passed to partition the suit land to place the land in schedule under separate dak and patta and to effect necessary order to be sent to the collector Kolkata for effecting the partition and for year. Who are you? The others, defendants. Who are the defendants?
They are from some other family.
This is a suit for partition.
So party.
Then how is a suit for partition these are? The plaintiffs are all. You are the defendant number one.
Defend number 1.
Huh?
Defend number 1.
And how do you come into the scene?
My name is mutated in the record.
How?
As per
Have you been issued an annual patta? Then how?
take it up on some other day. I will come prepare.
Not satisfied. You take it up at tomorrow at 2 or 2. This needs to be finished. You don't require the other thing. How you can have any right in respect to an annual patta land? Are you in possession?
Yes.
How?
By that mutation only.
By dispossessing these people? Huh? It should be dismissed. That must be the order, I suppose. And therefore you want to delay it by way of not impleading the former defendant.
They have taken steps on
Then,
first. They have wrongly made them as performer as well.
then what is this 2023 matter? It is still going on. It is the matter again on 25th of March 2025 at 2 p.m. You need to finish off this second matter. What is this matter?
Case, the appeal was closed on the ground of abatement that we did not substitute the legal heirs of this is respondent number 2 as per order dated 23/9/2022. Thereafter, we filed 3 applications. IASA 1780, 1781, 1782 of 2023. Legal heirs of respondent number 2 after service of notice, prima facie ground has been taken in objection that
Wait. Delay not yet condoned. What happened?
Filed my objection.
Why?
Also, in this case, we have already informed them about the death of the respondent number 3. Thereafter, on 3-4 occasions, they did not appear. Thereafter, the appeal was closed. Lordship. Thereafter, they have filed this IAC bill 1780 by incorporating a dead person. Lordship. Lordship, kindly see this parties, page 2.
Who passed that order? Putting it into abatement? Where? I remember. Many times he has stated about this thing and you did not take any steps.
All the orders, Lordship, along with my objection.
So there is a delay and you have delay as regards abatement of respondent number 2. Who is respondent number 2?
Both
You-
of the
Yunis
plaintiffs,
Ali.
respondent number 1 and 2, both are plaintiffs. They purchased a plot of land jointly by a single.
Ah,
The suit was for right title interest and recovery of possession.
After closing of this second appeal, we have again started our execution petition, then they have filed the substitution. 7080, your lordship will find in page 2, the applicant number 4, Santosh Chanda, within bracket lordship.
There is an application for striking out the appellant number 4.
What happened in this case, I have submitted an application stating that, yes, that mistake has been committed by while drafting. But regarding the substitution of legal errors of deceased appellant and number 4, although we have found, but the person, they are not interested anymore to coming before this honorable court in this application to get imputed, substitute the themselves.
Now, what are the other applications for? 1780, 1781, 82 are what applications?
1780, yes,
Is a delay of
379 days.
for the purpose of,
Filing of application for substitute.
this is response number 2. And where,
Now, down,
where is the RSA main form করছে? None appears for the appellant, is so and so, so and so. It appears for the court, the counsel for the head applies this court, further appears that only one, the counsel for the appellant sought for time for it. Taking into account that no application has been filed for substitution as well. Further to that, taking into account that if your joint decree passed in favor of the respondent, where the plaintiffs in the suit and in view of the abatement of the instant appeal insofar as the appeal avails as a whole and consequently they can be no decree passed in the consequently. Now, what is that? Enough opportunity was given. How do you explain it?
in this case, taken down at,
What is your explanation?
applicant number 3, you are the other defendants in the main case. So she was not aware of the fact. So she was.
No. The court had, she having informed this court in
Yes.
2021. How do you justify not taking any action till 2024?
That we have informed you. No?
What?
On that, okay, at that time when we have been supplied with the list of legal errors that we have informed over telephone. But they
No,
were,
that means they are not interested.
yes, thereafter, the petitioner number 3 was the appellant number 3 in the case. She has came before this honorable court stating that she was not aware when the execution proceedings started after dismissal of this appeal. She came.
No. That is different. You say that you have informed by telephone.
I
Either-
didn't follow.
So you must have informed the appellant number 3.
We were not, I do not have any contact number. At that time, I did not.
Whom did you inform?
I informed the appellant number 1.
So appellant number 1 knows.
But lordship,
I think we should dismiss your plea. No ground.
appellant number 3, your lordship.
If they are not interested, every time another appellant will come up with another excuse. Either ask the appellant number 3 to take action against you under the bar council, then only I will interfere. Otherwise, no. Ask him to file an application before the bar council against you.
Well, I've also.
You informed, they
Yes,
say, but if you have informed, if you were, that means as we are holding the brief for appellant number 1, 2, and 3, because the 4th could not have been because the 4th is a dead person. So if you have informed on behalf of respondent appellant number 1, 2, and 3, and they say that 2 and 3 were not informed, you have not taken any action as per law. So it is an apparent misconduct. So ask them to file an application before the bar council.
Well, that
Otherwise,
was
no.
informed over application, sending an application by post also at that time.
Yeah.
I do not have the copy with me right now.
Then if you have informed, then either you should not appear, or if you appear, then we will presume that you have informed, then they were not bothered for more than 1 year, 2, 3 years, 3 years. Think about it. What do you say, madam? I know what you have raised, I've seen it. But the question, because I've seen it, every time you come up and tell me that he has died and this appellant number 4 has died and this person has died, these are the details we have also furnished, but they are not a substitute. It is under such circumstances, I gave them around 3-4 opportunities. Then only this, the matter was closed. They are not, and that day also they did not appear.
After COVID period, also lordship 3 months extension period was also given lordship. Thereafter, it was
Everything. Okay. Anyways, think about it. Whether the appellant number 3 will like to proceed to the bar council against you. If not, no.
I have done my duty.
You have done your duty, so therefore, either you have done your duty, which you say, I believe you.
But they did not came to Honorable Court.
So if they have not come, in spite of being informed, you can't help it. Okay, leave the matter. Before, let it go before any other court. On 4th of April.
Much obliged.
34.
May it the lordship, as per office number 11/3/2025.
Service
Service number
complete.
1, 2, 3, 4, 6, and 8 completed lordship. Respondent number 5 expired lordship.
And 7?
7 also complete lordship. It was received
5
by the brother,
expired.
by brother. Yeah, 7 received by the brother lordship, and 5 died lordship. 5 expired.
So you are going to take steps.
Lordship, legal heirs of 5 are already in this case lordship.
No,
Why
not necessarily. Who is there? 6?
lordship?
Who is legal heir of the respondent number 5?
5, 6, 7, and 8 lordship.
Mr.
I
P.
present
Bordley
six.
submits the respondent number 5 had expired. However, his estate is duly represented by the respondent number 6, 7, and 8. So considering the above, the name of the respondent number 5 is struck off. Full stop. It is also seen that the LCR has full stop. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court, and the registry shall make necessary changes in the cause title of the memo of appeal and also update the same in the CIS. As a LCR has been duly received, list this matter for hearing in the usual course. Liberty given to both the parties to file appropriate application for early hearing.
Obliged, Your Lordship.
35.
Lordship, as per office note dated 10/2/25,
Who is
Correct.
respondent number 1?
the petitioner claimant. Newspaper publication we can make
You file application for it.
application for. But then can we do dusty for that also application?
Want to do Dusty, I can fix it for Dusty.
Yes.
Ms. Adi Majumdar, the counsel appearing on behalf of the appellant submits that she would like to, the appellant insurance company would like to take steps by way of Dusty. So, list this matter again on 19th of May 2025. In the meantime, the appellant insurance company shall effect service upon the respondent number 1 by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next.
Early of time.
36.
Service complete.
Lordship will disclose respondent 1 not complete.
1 complete. Service report has been received for 1 and 2. Service on hand have been received. 1 not complete. Which one?
I am here for respondent.
3.
Lordship, as per the report of the
Ah, it is. Respond number 1 or complete 1 again. Please, give them a good reason. Which one?
one is the lordship, plaintiff. Lordship, I mean, be allowed to take steps,
upon one floor, respondent got two lordship,
What is the dispute?
land. Adjustment land lordship.
How is one is connected with two and three?
Lordship, the one is represented by the two lordship.
How do you know? Oh,
The
yes. Two is
lordship, the
complete.
plain lordship.
Yeah.
Plaintiff is 70 lordship. Type copy.
So one and two is the plaintiff.
Yes.
Three. Mr. Chakraborty, you are for three. What is three? How is three connected with one? Are you also a plaintiff? Huh? Plaintiff, plaintiff. It's a joint plaintiff.
He also 20%.
Yes, one, two, and three are all plaintiffs. Come down, yes. Monthly tea company became a plaintiff. How?
As per office note that the address mentioned in notice was not within the jurisdiction of the court.
Huh?
As per the X.
No, understood, but
That-
what is, I don't understand one thing. What is number three? Mr. Chakraborty? You see the decree, page 50. One, two, and three are all the plaintiffs.
The plaintiff number one company was run by Peterborough two by Paternity State Lordship.
How are you connected, Mr. Chakraborty? You are also a plaintiff. Kindly see page 50. It's the decree. Isn't it? So you can, if you are appearing for three, why not one and two, if you are jointly filing a suit?
Upalatama has been given,
Understood everything, but ask your client, because it's a common plaintiff, and two is being represented. Two has been served. Now two happens to be the same person who is going to represent one.
Yes. Constituted attorney.
So therefore, is the suit was made in that manner.
Okay, man, I'll obtain instruction.
Yes, S.K. Chakraborty appearing on behalf of the respondent number three admits that as the respondent number three, the respondent number one, were co-plaintiffs in the suit, he would obtain instruction as to whether he would be in a position to appear on behalf of matter again on 9th of April 2025.
37.
Please, your location. Service is complete.
What is this CRT? Landlord tenant.
Yes.
What is there?
Otherwise, Supreme courts have decided against me.
And when you are vacating,
No, your lordship, there is one particular point.
Tell me,
Jurisdictional error which has not been,
where,
before deciding what is there in 5(4) of the act, the court,
where about 5(4) Bonafide requirements?
yes, but 5(1) was not decided. That is when the rent has fallen due.
Where about that? What about Bonafide requirement?
Bonafide requirement, the trial court has decided in my favor, but the appellate court has overturned it.
It's a finding of fact.
But your lordship,
Nothing wrong.
regarding the Bonafide requirement, they could not show any evidence in regard to that.
What evidence?
Evidence, they had claimed that that is the prayer hall. Prayer hall is in the second floor of the building. So these old persons, old people, they have difficulty in climbing the stairs. But that is only a statement made. They could not show any proof in regard to that. So
They have to go and walk out there, whether they are in a position to walk to the second floor.
that
before
has
the
been
court.
discussed by the trial court.
The judgment, 2014, what is that Ravindran judgment? Like one judgment,
Landlord is
it
the
is
best.
absolutely within the ear of the landlord.
Landlord is the best person to.
The landlord, nothing remains then.
Well, your lordship, there is another judgment passed by the apex court that says that the need of bona fide requirement, that has to be a real need and not merely a desire. So here this appears as if it is a desire of the landlord. In the present case, it appears as if it is a desire and not a real need, because he could not show the, no one came before the court below.
Huh?
The devotees, no one came before the trial court that to show that they were facing problems as such.
No evidence.
There were two witnesses, the representatives of the Gurudwara. Actually, this is a Sikh organization, Sikh religious organization, matter, in which they are the tenants on the ground floor. Now, we in our claims and thereafter in our chief also, we had stated regarding the arrangements made in the four-storied building. Now, what we categorically said is that there is something called Nissan Sahib, which is a religious flag, and which has been established in the third floor as a stopgap arrangement, but which is required to be brought down to the ground floor where the tenanted premise is, so that the elderly people have easy access for offering their worship. Now, that was our categorical stand taken, because so far, my lord, the third floor, which is being used for keeping the Nissan Sahib, that third floor also is used for langar. Langar, your lordship is aware, it's a dining hall. Now, because of our requirement to bring down the flag, that is the Nissan Sahib, to the ground floor, we sought for, my lord, eviction of the tenants on the ground of bona fide requirement. Now, in my lord, so far as the evidence of the two witnesses, that is PW1 and PW2 are concerned, there are, my lord, admittedly, apparently there are minor discrepancies. But one fact which remain unreported is the fact that Nissan Sahib was at the and still remains at the upper stairs, and which is required for Nissan Sahib is meant for offering worships, and for offering worship for the convenience of the elderly people, my lord, that is required to be brought down to the ground floor. Now, for that, my lord, the learned, of course, the trial court did not concur with the pleadings of the plaintiff, but the learned appellate court, my lord, differed from the findings of the learned the learned trial court, and eventually, my lord, taking into consideration the rulings of our high court as well as honorable appellate court regarding the on the issue that the landlord is the best judge to decide regarding the bona fide.
What is he doing out there in the tenant?
They are running a grocery shop. Sir.
Go to the third floor. Go there.
I'll seek instruction.
The third floor is already meant for langar.
No, nothing. Your lordship will once come to the finding, the trial court.
No, no. I won't look into this. Here it has been stated out there, petitioner in his process deposed that even though the defendant had created nuisance by blocking the staircase of the temple, but admitted that they have never objected to the actual.
Bonafide requirement, page 60, appellate court finding. Page 60, issue number 2. Appellate court finding.
And how long you have been there?
Since 1966. 1966.
56,
66.
60.
66.
Where? Here in Pennsylvania?
Not lucky. Not lucky. Not lucky.
So the property is now yours. Then
Your Lordship may once come to the finding of the trial court at page 34 regarding Bonafide. At para 25.
there's no stay.
No, no stay.
You go ahead.
We have filed the execution.
Now what is here? Why the office note service?
Service and record.
LCR has been received
Yes.
and you have it appeared. So nothing, you put it for admission.
Admission.
It's a matter for admission. When?
As per the convenience.
I have no convenience. I won't be here from 1st of April. It's the matter for admission on 4th of April.
Other than court. Court I have some.
So let's have it after vacation
Right.
on 23rd of April. 2025, taking into account that the service is complete. And the calls have been received.
I have a gate for the full response. I have a gate for the.
Put your name.
Fine. Obliged.
38.
Some of the respondents appeared, okay. We have not taken usual process, so if you.
So 11 and 13. Service not complete.
16, 17, 18, 19 perform.
It's okay. 11 and 13. Service is not complete.
Third appearance for 1.1 to 1.345.
No, madam, 11 and 13 service is not complete. You want to take fresh steps? So and so submits that you like take fresh steps upon the respondent number 11 and 13.
Lordship,
Steps be taken by way of registered as well as usual within 7 days from today. To establish the matter after completion of service upon the respondent 11 and 13.
Lordship, other than memo, I think we haven't received any other document to kind of direct.
Lordship may strike out the name of 16, 17, 18, Lordship, 19. They are
They have been served.
performer return
Unserved notice.
after address out of station. Lordship. 16, 17, 18, 19.
1.2.
1.2 Lordship, no.
Who also?
address. Lordship, for them, I will take instruction whether any other address is available. 1.2 and 2 Lordship. They are main respondents.
It is seen that the service upon the respondent numbers 1.2, 2, 16, 17, 18, 19, as well as 11 and 11, 12 and 13 is not complete. Also, this is the matter after completion of service.
39.
LCR service is complete. However, the LCR has not been received. Registry shall take steps for repositioning of the LCR of PS 104 of 2025. 2025. One why not? Killing it. 2015. Service upon the sole respondent is complete. However, the LCR of 104 of 2015 has not been received. The registry shall take effective steps for requisitioning of the LCR of the type of suit.
This matter will be listed along with RSA number 179 of 2015.
Instant instant appeal be listed along with RSC number 179 of 2010. Service upon the respondent number 7 will be complete. List the matter after completion of service upon the respondent 7.
41.
Lordship, as per the office note dated 10/2/2025, respondent number 1 was expired. And 4 also expired. Respondent number
If I
5
could-
and answered due to incorrect father's name.
What is this? Yes, we don't issue notice in these matters. No. You're taking into account. What are you challenging? It is seen that the survey, it is seen that the appeal, the instant appeal, which is an appeal filed under section 100 of the Code of Civil Procedure. The appeal, it is seen that the present appeal, which is an appeal under section 100 of the Code of Civil Procedure, is yet to be admitted by framing a substantial question of law. Taking into account the above, they list this appeal on 26th of March 2025 in the column of Order 41, Rule 11. The question of issuance of notice would only arise subsequent to notice can only arise once the appeal is admitted and not prior thereto.
42.
This service is the other side also appeared. So my parents can matter be taken up any other day money admission for me.
What are you challenging?
We are challenging the order at Alexa, please 55 million. And do we want to re-examine the exigent one? Yes, madam, the employer of the deceased. That was rejected.
Taking into account that the service is complete, leaves the matter for admission on 26th of March 2025.
43. Item 43.
The service being complete, lists this matter for admission on 4th of April 2025.
44.
Yes, Mr. Rao.
So this is served through processor when there is a report on 4th of March. And the stay was served upon him on 7th March.
You have served?
Yes, Mr. Affidavit has been checked.
Who is he?
Milord, he himself, the respondent himself.
This court had duly taken note of that pursuant to the order passed by this court on 14 to 2025. Service have been, steps have been taken by way of justice. And in that regard, an affidavit of service have been filed. Consequent upon, this court in opinion deems that the service upon the respondent is duly complete. At one respondent, not
Oh, sorry.
this matter for admission on 26th
26th of March.
26th of March 2024, 24th March 2024, at the stage of admission.
Today, hearing was to be considered.
And considered on which date this court shall consider on the interim plan.
Or like,
If I.
Justice service lost his affidavit filed today.
I appeared on behalf of the respondent number 1, madam.
Office note shows justice to also completed service.
You are paying for?
Respondent number 1.
Okay. So he filed an application under order 6 and 17.
Yes.
It was rejected.
Yes.
The application is rejected on the ground of petitioner present. I have already decided. So here, he only wants to bring on the relief of declaration about the sale deed to be bad.
Yes, only.
He didn't do. Because it is only going to delay the suit. Anyway, as the service is complete, let me fix it on 28th. 28th March, we fix it. Let me fix it on 27th of March.
27.
2 p.m.
Plus
2 p.m. We finish up this matter. Because there are many judgments where they allow only the relief to be inserted. No further evidence, nothing. It will be written by hand, it will be done. Whatever evidence he has given will be considered in that time.
obliged.
Or
27.
27. Taking into account that the service is been duly completed, this court fixes this matter on 27/3/2025 at 2 p.m. So the interim order passed on 19/2/2025 shall continue until
Like,
46.
Some more time may be given, Lordship, to take step by the usual, Lordship. Thusly, we have already taken. But no affidavit has been filed.
you have not taken steps,
Thusly, already taken, affidavit.
but you have not filed it.
Affidavit not filed, Lordship.
Then we have to fix another date.
Take, usual
Taking
process
into account, taking into account that the service is not complete upon the respondents and no affidavit of service have been filed, lift this matter again on 7th of May 2025. In the meantime, the petitioner is directed to take fresh steps by way of dusty upon the respondent numbers the respondents and then file an affidavit of service on or before the next.
Okay.
47.
that's the Lordship.
Yes, what is this early hearing?
Yes, my lord. My lord, 726, my lord, there is an order of place 8, my lord. Let's say receipt, my lord.
What is the ground?
Ground?
Early hearing?
Ali hearing, my lord, place 8, the order passed by this court, my lord, after.
I gave you opportunity to file an application, meaning thereby you have to give me a ground.
The ground, my learned friend, they are also ready, my lord.
Ready to, I am also ready, but the fact that I don't have the time.
My lord, for the lodging of this data, should, my lord. The only one part that is obstructed, my lord, I'm not able to use that part, my lord. Only section 15, they decided section 15, the Eastman Act, where my case is based on section 13 of Eastman Act. So my prayer, my lord, after due vacation, lordship may, it's the matter for hearing. Only that issue involved. Whether my
Mr.
case is-
Dekar, the problem arises, I would not be more sitting over this bench.
My lord, then, my lord, next week, then, my lord, this bench, my lord.
No, they say, you see, this closed, they have closed this got shut
My
down.
lord,
So many matters next week.
understand, my lord, understand.
And I have to go and sign in before leaving. Oh, that's not possible. Anyways, when do you want it? Because you see, let this matter come up
Again, order,
on 2nd of April. Let this matter come up before another judge is present, because that judge may take up. I would not like to, because if I take it, I'll fix it for hearing and I'll do it. It's so unnecessary, because otherwise it becomes useless. Once I pass an order, then matter does not get.
Yeah, I
listed.
can understand.
Okay, list this matter on 2/4/2025. Okay, on 4th of April.
Deep domestic.
49.
And Lordship, I filed my affidavit, Lordship.
What is this?
Transfer petition, Lordship. And their only ground is, financial inability. And I am ready to pay the cost, Lordship.
Oh, that the matter came up now before me.
There are citation, Lordship, you are aware? I am ready to pay the expenses, Lord, financial, Lordship. Their only ground is financial incapacity. I am ready to pay the expenses from Infructuous to Guwahati. Also, the accommodation charges. Here, Lordship, my father condition is very bad, Lordship, is totally bedridden. So in my condition, Lordship, the balance of incapacity.
Where have you filed it?
Lordship, I filed it on 12th, Lordship.
At Guwahati.
Yes, they have filed it at,
When filed with Pindy Court, because I have wanted to start with the Infructuous.
I have filed it at Guwahati, Lordship.
It's difficult for us to prevail in long distance.
They have only taken the ground of financial incapacity, Lordship.
Difficult to,
Difficulty, they have not expressed the reason for difficulty. They have said financial incapacity, and lordship, I am ready to pay the expenses.
There are six.
I have one judgment to rely on this.
There are six of my condition. There are six four. But he has no problem that he is only given over. But it's not difficult to travel for long distance. I feel travel. Yes, and it is difficult to have travel capacity long distance.
Lordship, may kindly see paragraph number 7 of the petition, lordship, page 5.
Yes, what is it? It says,
That the petitioner has no financial capacity to
quite
produce existence in the court of the learned principal judge at Guwahati to adduce evidence to defend the case. Moreover, in the family court, the petitioner is required to appear each and every day. Under the above circumstance, the petitioner face hardship in contesting the case by the opposite party for dissolution of marriage. On the other hand, the opposite party is financially sound person. That is, they have said their main contention is financial incapacity. And I am ready to pay the expenses for that one.
There are six. I have the difficulty, so they are long distance. It's difficult to come.
Long distance, lordship,
And
India to Guwahati, there is Rajdhani Express.
If a lady is difficult to complete the case.
It is the
And
safest
moreover,
train,
your lordship, that
safest train, Rajdhani Express. And when I'm ready to give, what you have given one citation, lordship, it is very clear
moreover,
that when I'm ready to give the expenses,
it is not the file a difficult principle here, my learned.
that is already
Respondent
stated.
has
That is already
stated.
stated by the honorable court.
That is the difficulty that is here in this case.
That is already stated by the honorable court. And lordship,
Good. Mr. Islam, we do one thing. He will provide us, yes, so this judgment now, it is very good. He'll provide a second class AC train ticket of the Rajdhani in advance. 2 years. He will provide along with a company. He will also provide a 3-star hotel accommodation. And further, how much amount should be paid?
that is not reflected in the order, lordship.
That's another 3,500. You should be happy.
Mr. Hotel will be little bit difficult for me, but it
No,
would.
no, here you are
Yes.
relying on the judgment 3-star hotel. Here in commute, na, family court. So stay here.
Ulubari. Ulubari.
Ulubari. Good, you stay there. London, Hotel London, you'll be happy. Hotel London, and then AC 2-tier. Ticket.
So far, Hotel London is
Is it
concerned,
there?
lordship, can I come back with some instruction?
Eh?
So far, Hotel London is, is it, Peter, we are ready, lordship. So far, Hotel London is concerned, can I come back with some instruction, lordship? On Friday, lordship.
You also come back with another instruction. If I say that you don't appeal, because that is not a family court. Here she has to appear every day. See, and it is an unnecessary expense.
Lordship.
Whereas you can participate there through your lawyer.
Lordship.
And it is only on the date when the court requires their attendance. Then you go. Wouldn't that be more beneficial for you?
Let me take my summary instruction.
I think that is the better option. Because I normally, if it was here, the district court was there, then I would not have. But here, every time she has to come. That is the problem of a family court. Whereas you don't need to go. There I can exempt that your presence is not required. You can appear through your lawyer. It's only so and I can provide you the video conferencing facility if presence is required. Whether it is available. I think it is available.
Therefore, I don't have any knowledge, lordship. I think it is not
People
available.
have, I suppose, but anyways, you just find out if it is. You are there in Kinsukia, na? You are there in Kinsukia.
Lordship.
Find out whether they have the video conferencing facility. Find out whether that can be done. And for your evidence, if you require, then you have to go only 1 or 2 days. I think that will solve the problem better than giving all these things, because this will have unnecessary, this will be expensive. And every time she will come out here, the matter may not happen. It gets delayed. But she has to appear every time, and the expenses every time would be something around 6,000-7,000. Which may not be in your interest. Except troubling her out here to come, it's a different aspect of the matter.
We are that.
So instead of that, if you are only to appear, which I normally pass in these type of matters, You only appear out there when it is necessary. Normally, you will be appearing through your lawyer. And it is only on the date of cross-examination. If your presence is required, then you appear.
Okay, fine, Lordship. Let me come with some inspection of the Lordship.
When?
Friday, Lordship. This Friday itself.
It's the matter on 21st of March 2025. It's the name of the personal.
Then it was 20, Lordship.
20.
Then 21st, I am not there, Lordship.
Okay, 26th of March 2025. In name of the personal, shall continue.
Diploma.